Well, I want back to mention item number 2, my lord. No, lord, some related issues are pending in the Supreme Court, my lord. In fact, Lordship had deferred this matter earlier also on that day, my lord. Our matter is fixed on 23rd of August, my lord, Supreme Court, my lord.
And counsel, Mr. You are Mr. M. Datta,
And with the my lord.
representing the petitioner submits that identical issues are pending. Issues identical to the one agitated in this PIL are pending consideration before Honorable the Supreme Court and thus consideration of the instant PIL. What is the writ petition about?
Well, writ petition is by my lord, by one of my friend, my lord, who has 5 ministers, my lord. That is also with regard to my lord, Aadhaar only, my lord.
What is basically the controversy? Let us know.
My lord, he's the individual, my lord, who has filed, my lord, this application, my lord, for my lord, seeking Aadhaar.
What is your PIL about?
Oh, my PL is, my lord, with regard to my lord, granting of my lord, Aadhaar card, Aadhaar, my lord, enumeration to those who have been left out in the NRC process, my lord.
All right. Is under consideration of Honorable the Supreme Court and thus hearing of this petition may be deferred for the present. List after 8 weeks as per.
My lord. Well, item number 3, I've taken consent of my learned friend, man. Take that.
Let learned counsel come and say.
My lord.
To mention item number 26 also. Under last
36 or 26.
26.
What do you want?
Last occasion, Lordship, the respondent filed a record before his honorable court. They are supposed to furnish us a copy, but till that they have not furnished.
Who is there for the respondent in this case?
Respondent, we have taken consent of the.
No, but let us know, let us at least direct them to provide you the record. Let the matter be called out then. Let the matter be called out.
May it please your lordship, with the consent of the other side, I would like to mention item number 28. Lordship, the matter may kindly be adjourned as learned senior counsel, Mr. K.K. Mahanta is not well today.
It is stated that arguing counsel, Mr. K.K. Mahanta, senior advocate, is not well, and thus a prayer is made to adjourn the matter. Let's stop 2 weeks. The other side has no objection. Let's stop 2 weeks.
Much obliged, lordship.
May I please, your lordship, item number 22, my lord.
What? 22.
22, my lord.
Yes.
My lord, same issue is raised in another writ petition, my lord. So may I pray for listing both some writ petition? But second is
Petition or a writ appeal?
writ appeal, sorry, my writ appeal. But the second is, my lord, to be registered, my lord.
Is yet to be registered.
Yeah, after 2 weeks, my lord.
Land counsel, Mr. Kadir,
Yes.
submits that a writ appeal involving identical controversy has been filed and thus, for the present, this matter may be deferred so that the cases can be heard together. Let's stop 2 weeks.
Obliged.
May I please your lordship, I beg to mention item number 27, my lord, with the consent of the other side, my lord, matter may be adjourned for today, my lord.
Why?
As a conducting counsel, Arbora is unwell today, my lord.
It's stated that arguing counsel, Mr. R. Boda, is not well and a prayer is made to adjourn the matter. Let's stop 2 weeks.
My lord, however, there is a similar matter pending and it is fixed on 23 of May, my lord. Both the matter may be taken up.
23rd May,
Yes, my lord.
list on 23rd May along with writ petition number 1, writ appeal number 1.
Deeply obliged.
As per.
Of material.
May I please your lordship, I beg to mention item number 15.
1-5. Why?
And due to some personal difficulties, my senior will not be able to appear to
Ms. KL is not here. Who is your senior?
SCKL.
He is not here today. It is stated that counsel, standing counsel, Mr. KL is not available today and thus a prayer is made to adjourn the matter. List after 1 week.
I beg to mention item number 7, my lord. Due to my 17, my lord.
Yes.
Due to my illness, severe illness, which get to my throat, my lord.
You are Mr.
M.S. Ali, Muhammad M.S. Ali.
You are appearing in item number 7.
No, my lord, 17.
17. Mr. Ali appearing for the appellant submits that he is unwell. This is for admission.
Yes, my lord.
You won't even need to argue. Wait for a while. It's a formal step to be taken.
22nd May, my lord, matter may be
List as after 1 week as played.
deeply.
May I please your lordship, my lord, on behalf of the health department, I pray for adjourn, passover of the matter for today, my lord. Because in this matter, advocate generally is appearing, my lord, he has some personal difficulty.
It is stated that London Advocate General Mr. Saikia is not available today and thus a prayer is made to adjourn the matter list after 1 week.
Lordship, I'm for the petitioner. Lordship, interim order may be extended.
Interim order passed earlier shall continue.
Obliged.
Obliged, my lord.
Matter number 1 of daily list for order.
May it please the lordship. Lordship, in this case, lordship, LCR is not received. And as agreed by my learned friend, lordship, matter will be sent to mediation, lordship. As there is a family dispute.
Service has been effected on behalf of the respondent and learned counsel Mr. So-and-so has appeared on her behalf. The lower court record has not been received, registered to do the needful. In the meantime, on the request of learned counsel for the parties, the appellant and the respondent are directed to appear at the mediation center, Rajasthan, Guwahati High Court. On when will they appear? Date?
After
You just suggested on so and so date, so that the possibility of an amicable settlement can be explored. The report of mediation proceedings shall be sent back to this court, forwarded to this court. After the same are concluded, list up to 4 weeks to give a date on which your clients will appear.
lordship, after 10 days, lordship.
Even a date up to 10 days for appearance before the at the
First of June.
first July.
Obliged.
In 3, whether the council is here. Call out item number 3.
Item number 3.
All right, list along with so and so. The PIL के साथ लगाने पर.
Item number 4.
Yes. You filed the rejoinder affidavit?
Yes, your lordship. The rejoinder has been filed. I've filed a reply, affidavit and reply to the rejoinder, your lordship.
So the pleadings are complete. What is the appeal about?
This is an appeal filed under section 28 of the Hindu Marriage Act, your lordship. Intentionally, a wrong address has been given in the petition which was filed before the learned court below, stating that I reside at Chandra Prabhava, that is opposite Hanuman Mandir, ward number 7, GF Road, but that is not the fact. I'm residing at.
So then you are required to file an application for recalling of the ex parte decree, 9 Rule 13. Why didn't you go there?
Your lordship, I have assailed another various other factors also. That is, one is the misleading, that is the respondent has misled the honorable court.
Understood, sir. So if you go to the family court, file an application for setting aside of the ex parte decree, the proceedings will be reopened. You will get an opportunity to lead your own evidence as on date. On this evidence, what is to be done? Let us know.
The record may be remanded and let the proceedings start. That is, I may be given an opportunity to defend myself.
For what reason? You never went to the family court and raised this issue.
I have not received the notice also.
Gentlemen, once you came to know of the judgment, you came here and filed the appeal. You are required to file 913 for setting aside of the ex parte decree. We'll admit it and put it for hearing in due course. What good it will do to your client?
I may be given the liberty, that is, I can file a petition also, if that I'll do.
Let us read your pleadings. So you want us to dispose of this appeal, giving your client a liberty to move for setting aside of the ex parte decree?
That will also be possible. My intention is relief only, your lordship. I may be given an opportunity to be heard.
We can't say, we'll just give you the liberty to file the application. What will be the fate of application? That will be for the family court to decide. If your plea is found to be bona fide, maybe it will be accepted.
There are various other reasons also, your lordship.
It's all right. The parties are represented, pleadings are complete. Admit list for hearing in due course. LCR? LCR is received.
Item number 5.
May it please. In this matter, I was appointed as the amicus curiae, my lords. Because the petitioner, he has sought to review an order passed by the division bench of this High Court, wherein the appeal was dismissed. So initially, he had filed a writ petition as the writ petitioner, challenging the order of penalty culminating out of a disciplinary proceedings, my lords. That was in the year, my lords, thereafter, my lords, that order was, the writ petition was dismissed. Thereafter, he had preferred a writ appeal, which was also dismissed on 4/6/2012. My lords, thereafter, my lords, in 2021, he had filed an application for review, my lords. I must admit, my lords, perhaps because the petitioner in person was not instructed in law, my lords. The petition also, my lords, grounds of per se grounds of
Review are not available.
but nonetheless, my lord, the lordship would fix it for admission. I'll nonetheless give an effort and try, my lord, if something can be done, my lord.
Review can't be fixed for admission. It's always fixed for orders.
Hello, madam, I'm so sorry, my lord. That's
It is already there.
After a week, I'll do some.
You want us to direct the petitioner to be here?
My lord, I have his number, my lord.
So call him
I'll
and
call
counsel Mr.
Yeah.
Mahanta submits that he desires to inform the petitioner regarding the date, petitioner, and to instruct him to remain present when this review petition is taken up. List on. State the date on which you want. 9 June.
9 June.
9 June.
Deeply obliged, my lord.
Item number 6.
Mr. Learned Counsel, Mr. P. Mahanta, amicus curiae, submits that it would be better if the petitioner is present when the review petition is taken up. He states that he will inform the petitioner about the next date. List on, sorry. All right.
Deeply obliged.
Deeply.
Yes. Steps not taken for, it's delayed. The appeal, connected appeal is delayed despite direction given by this court on 22nd December 2022 in IA number so and so. Steps for effecting service on the respondent have not been taken. Last opportunity of 15 days is granted to the appellant's counsel to do the needful in case the requisites are not furnished by 15 days. 18th, 18th, 17th. By 6th of June, the instant IA and the connected writ appeal shall stand rejected for want of prosecution without further reference to the court. That is the point order.
Item number 7.
Council, why do you list it again? And we give them one clock.
Late,
The
please, your
petitioner,
lordship.
The appellant shall also be informed of this order through email if possible. Yes.
Lordship, as per Lordship's last order on 8/5, still now nothing has been done by the department, Lordship. And these children are still awaiting admission under the RTE Act. And Lordship, respondent number 12 has been harassing the parents, asking them to sign blank papers, indicating that no grievances against the school. And
Is there anything on record other than your oral allegations?
we can bring it on record.
So
Lordship.
you have to, if
We
you
will
want to make
file a-
allegations against any particular institution,
Yes,
these things have to
Lordship.
be in writing so that they can
Lordship, our
respond.
ground survey, but the volunteers who are doing the survey, if I may be allowed to file an affidavit myself or by my co-founder. Lordship.
Whatever you feel. If you are making certain pertinent allegations against an
Lordship, we
institution,
put in the petition earlier also against some schools who have.
today you
not-
have stated about respond number 12.
12
Do
will.
you want to
and
bring those allegations on record?
We will bring it, Lordship.
All right. What
A
about
short
the
date,
other
Lordship.
admissions? Mr. Mazumdar,
And Lordship, the Secretary Education has not till yet communicated the order to the schools. This is what the schools have told us.
yes.
I have an instruction of today morning, my lord.
It seems some schools have appeared today, Lordship,
Yes.
after receiving the notice. Can I have a copy? Yes, sir.
What is the content?
My lord, a meeting had been held with the particular districts where the allegations are leveled. My lord,
Hmm.
worship may like to have the last bullet point, my lord. As per report of the Director Elementary Education, based on the reports as received from the concerned district education officers, it is stated that the hearing of the concerned schools have been conducted, and in this regard, some head of institutions have reported that students were approached the respective schools for free
We
admission.
give you 7 days time to admit the students. Get the
My lord,
students.
there is only one aspect, my lord. The modality of choosing a student. If there are more students than the number of seats reserved.
Your letter doesn't indicate so.
No, my lord, it doesn't indicate, but that is what, my lord, I have to place a few things before the court before we
25%
can.
has to be reserved.
Since
You
Lordship.
feel 25% as per merit
is
or
all,
whatever the
Lordship.
criterion is.
There is no criteria in the RTA
is-
education. or-
You devolve criterions.
My lord, that is
Rational
what-
criterion has to
that
be
is what is
devolved.
also there in this instruction.
Yes.
We are formulating, we had given an advertisement, we had said that this is how the application forms have to be made. Now, my lord, when the RT does not allow us to make a selection of those persons, if there are more than number of the persons, everything has to be looked into and the modalities are being prepared. We will not spare the
You
schools, my
want
lord.
these people to apply online. They are already deprived. How will they apply?
We are not on
Lordship,
the- we are not
after
on
the
the-
RT Act has come into place, we do not have the complete implementation. Neither the education department has a website. These children are supposed to apply in the website and the district has to ensure that these children go with the district education officer will and see where these children will go. They do not have anything in
We
place,
will take
Lordship.
up the matter day to day.
This
And
is
Lordship,
taken.
these
They
Day
won't
to
sorting-
day
be-
basis.
These
Tomorrow come out with the
sorting-
steps you have taken.
The government is, my lord, is, we are not saying that it will not be implemented. It
Is
just-
there a
give us the-
dedicated portal on your website?
My lord, yes.
Why don't you put up a portal
That
for
portal-
RT admissions?
Lordship, that is also
portal
one
is-
of
That
the
is what the
ways.
report says, the portal is being prepared. We have to put in a certain modality.
When did the
where-
RT Act come
because
into
we
force,
cannot-
sir?
Can we not?
When did the RT Act come into force?
But that.
2009, Lordship.
My lord,
Until date,
still
nothing
you
is
are-
the
happening,
orders of this
Lordship.
honorable court, my lord, we are putting it in place. The schools have to give us the information.
We will keep
without-
your secretary present on every date of hearing till this process is completed.
Lordship,
Mr.
I have
Katniar
one-
is, yes,
Lordship, these 49 children, only 3 schools in Nagaon have admitted 15 children. Apart from that, no one is coming forward. And the children, Lordship, please let me finish. Some children have been admitted by paying the fees and the schools are insisting that you pay the fees, otherwise we do not keep your children in school.
you file the affidavits.
I will
We'll ask them to
keep it, Lordship.
discontinue the recognition of the schools.
Yes,
You file the affidavits.
interestingly, most of these schools are not recognized also. I'm coming up with another PIL on that.
That is a
Very soon,
different
Lordship.
issue. That is a different issue. If they are not recognized, how they are imparting the courses? We don't understand.
Secondary registration, but they do not have the elementary registration.
Oh,
This is a big scam going on, Lordship. And we are preparing.
Don't ask us to comment on that, please.
Lordship.
Without
my-
the matter being before us, we will not make any comment. But yes,
My lord, yes.
Lordship, my.
49 children are there.
These 49 children,
These 49 children, my lord, there are also reports that they have, some of the children have not even applied, my lord, names.
no lordship,
Let there be-
we will give
Let me
everything,
finish.
lordship.
The meeting, you to finish.
Lordship, we
Let me
have given
finish.
the chart in the repetition,
I just
lordship.
put in one thing, my lord. Let these schools within a day or two file an affidavit saying that these children applied, they know of the existence and they were refused or not refused. Thereafter, my lord, the government will take
Lordship,
every
it's
action
my
possible.
friend is taking
We
this
are
children.
directing your secretary, Mr. Mazumdar, we are directing your secretary to take all steps to ensure that if they have not filed the application, their applications will be filed and they will be admitted within the next 7 days.
And-
Otherwise, on each date of hearing, he'll be paraded here.
Let them, if they apply, my lord, the schools
No,
have to
lordship,
comply.
If they have not
I'm
applied,
defending
you-
anybody. Lordship will not take it that I'm-
Once they have come to the court,
My lord, yes.
these all are excuses.
I'm not trying to defend. or
Don't
give an
even
excuse.
think of
I'm
that.
not doing that, my lord. It is only the.
It's a
schools
mandate
who
of
admit.
constitutional provision.
It is the schools who admit it. The schools have to say. We
Lordship,
have the
and
standard of the school, my
extra-
lord. We will be very strict. I assure lordship, my lord, we'll go for derecognition. There's no problem. We are not in favor of the schools.
Yes, yes,
We
madam.
simply need to pay the
Lordship,
fees back to them.
Annexure G has the complete list of 49 children who have applied, lordship. My friend cannot ask for anything more. now.
Annexure G, let us see.
Yes, lordship.
Where is your denial?
Annexure G is page
Where is the denial?
63 to 67.
Yes. Where is your denial? Mr. Mazumdar, where is your denial to annexure G?
My lord, I have
Show
not
us.
filed, my lord, I have not filed an affidavit, my lord. I have placed the instructions as I received today morning. Lordship will allow me to file an affidavit.
All
I'll have
right.
the instructions from
The
the school and I'll
petitioner
file the affidavit.
present in person states that till date, comma, out of the 49 children,
15 have been admitted.
comma, 49 children whose names are set out in list annexure G, comma, only 15 have been provided admissions under the RTA Act. She alleges that many of the schools are demanding money for admitting the children. It is further alleged that the respondent number 12 has been exerting pressure on the parents of the children to sign blank undertakings.
And respondents 17 and 21 continue to take fees for the children who are studying their lordship.
It is further stated that the respondents number 17 and
21 lordship.
21 are charging fees from the children who have been admitted in RTI, RT,
Yes,
from the
lordship.
children who have been admitted under the RTA Act. She may bring these facts on record through an affidavit.
Lordship.
In the meantime, comma, Mr. Mazumdar shall instruct the Secretary, Department of School Education to ensure that the 49 children indicated in the list annexure G are provided admissions into the schools concerned.
Lordship will fix.
As per the mandate of the Act, list on 24th of May. On that day, in case the order is not complied, comma, the Secretary shall remain present in the court.
Much obliged, lordship.
Obligation.
Pen number 8.
Copy of this order shall be communicated to the Secretary Education Department forthwith.
Yeah, please, lordship. Lordship, in terms of last order, lordship, we have taken step in respect
You have?
of service report in respect of the respondent number 6, lordship, is waiting. Maybe listed other tools, lordship, because service report. in respect-
Service report is,
As per official dated 15/5 plus.
respond number 6. No one is presently representing the respond number 6.
My lord, no,
You have taken steps.
my lord, we have taken it.
Oh, all right. Notice has been issued to the respondent number 6 on 15th May. Thus await return of notice for 4 weeks. Or 2 weeks, 2 weeks.
Pen number 9.
Oh, lordship,
I appear for respondent number one, Lordship.
Yes.
Respondent number two, they are to comply with the order for paying compensation, Lordship. Whether he has served notice on them, Lordship. Respondent number two, Lordship.
Yes.
Number two.
No name is reflected in the first list, I think.
Yes, Your Honor.
Number three, presumably learned advocate general has put in appearance. Number two, service is not complete.
Actually, we have started the justice service, my lord, and submitted the additional affidavit yesterday only, my lord.
And counsel for the petition submits that he has filed affidavit of service upon the respondent number two in the office yesterday. They are still to check and report, and in case the service has been effected, comma, to list the matter in the next week.
Master.
Obliged.
Matter number 10,
Yes, please, Your Lordship.
My lord, I am appearing for the respondent in this matter.
Yes.
Your Lordship, there's a condemnation delay, Your Lordship, for 20 days, Your Lordship. only.
What do you say, madam? On condonation of delay?
Lordship, my lord, the grounds are reasonable and it's just 20 days. So the matter may be taken up on merits. I do not have the objection to the condonation application.
MSP Agarwal puts in appearance on behalf of the respondent. The matter comes up for orders on.
As legal aid counsel, my lord.
While on behalf of the appellant seeking condonation of delay of 20 days occasion in filing of the connected matter appeal. Full stop. And counsel for the respondent has not objected to the delay being condoned. Otherwise also, comma, on going through the grounds of the application, comma, we find that the delay has been satisfactorily explained and hence the same is condoned. The application is allowed. The connected writ of matter appeal shall be numbered and listed for admission after 1 week. Name of MSP Agarwal shall hence
And copy,
copy of the appeal shall be provided.
it is being shown, my lord, my only humble.
A copy of the appeal shall be provided to the counsel for the respondent.
Obliged, Your Lordship.
Deeply obliged, lordship.
matter number 11,
My lord, the matter has come for condemnation of delay of 113 days, my lord. The state has filed an appeal. It has come for the first time, my lord. So notice may.
Issue notice of the interlocutory application to the respondent. Steps for service be taken within 7 days, whereafter process be issued to the respondent. You want dusty service?
My lord.
Dusty service is permitted. Rule is made returnable in 4 weeks.
Diploma.
matter number 12,
Lordship, I seek a week time, Lordship. Get the record.
For what? This is a fresh matter.
My lord,
Yes, Lordship, I have been asked to produce the record, Lordship.
All right.
my lord,
MS, yes.
in this case, my lord, in other occasion, my lord, lordship called for the record of the disciplinary proceeding, my lord,
She says that she is not having it today.
my lord.
Then counsel, MS M. Bhattacharjee submits that she needs one more opportunity of 7 days to keep the record available. List on 2nd June,
Lordship.
2nd June.
matter number 13,
My lord, in this, my lord, the common judgment, my lord, the various appeals have been filed, my lord, today it is listed first, my lord.
Hmm.
Judgment, my lord,
So
page.
you are the opening batsman.
Yes, my lord.
Yes.
My lord, here issue is that, my lord, we are, my lord, on the category of, my lord, drop teacher. My lord, Drop teacher. Drop teacher means, my lord, there are, my lord, school, my lord, in Assam, open, my lord, by public, my lord. Considering the, my lord, feasibility, my lord, subsequently government, my lord, takes up those school, my lord, subject to the, my lord, availability of, my lord, vacant sanction post, my lord. But when my school was at first taken by the state of Assam, my lord, I being my lord junior, my lord, I was not taken up, my lord, at that time, my lord, because shortage of my lord post, my lord. Therefore, my lord, I am my lord called my lord drop teacher. Subsequently, my lord, in view of the judgment of this honorable court, my lord, and taking a long process, my lord, my service was provincialized, my lord. But in the meantime, my lord, after the passing of the judgment, my lord, and my lord, before my lord, my regulation of service as a drop teacher, my lord, new pension scheme has come, my lord. So, my lord, we insisted, my lord, for my lord, our old pension policy, my lord, to be enforced.
You
upon
wanted
us,
to
my
be covered under the OPS.
Yes, my lord.
So well, the issue would be, when were you born in the cadre? That is a
Yes.
simple issue to be considered.
Yes, my lord. So, my lord,
Yes.
our case is that, my lord, as my lord, my lord, right was already decided as per the, my lord, judicial pronouncement of the, my lord, learned single judge, my lord, before, my lord, born of, my lord, new pension scheme, my lord. So, my lord, our, my lord, regulation, my lord, should have been, my lord, deemed to have been, my lord, done, my lord, from the date of the judgment passed, my lord, before new pensions policy, my lord.
Which is that judgment you are relying upon?
My lord, this judgment, my lord, page 208, my lord, 35, my lord, it is, I have annexed, my lord.
WPC 2284.
Yes, my lord. This is Jivan Chandra Daka, page, my lord, 35, my lord, 2008, 3 GLT 20229, my lord. It was decided on, my lord, September 1, 2003, my lord. And my lord, here, my lord, I am, my lord,
These judgments are not a part of the record.
record, my lord, the entire, my lord, case was argued on the basis of this judgment, my lord.
Where is it? It's not there. The appeal. Where have you filed it, sir?
My lord, page 35, my lord, this is the, my lord, Jivan Chandra Deka and others, my lord,
Yes, just hold on. 35.
35, my lord.
Yes.
Here, my lord, I am directly back to show, my lord, page 38, my lord, there is one line, my lord.
38 is the cause title continuing, sir. Internal page 38 of the judgment.
My lord, running.
What
page
is the
of my-
para?
My lord, here, my lord, it was provided in that judgment, my lord.
What
all
is the paragraph which you are referring to, sir?
My lord, the Roman 4:6, my lord. Page 38 of, my lord, my memo of appeal, my lord.
Yes.
It is, my lord, Roman 6 provided that, my lord, along with other, my lord, condition that all appointments.
Appointments made will be prospective.
Yes, my lord.
So prospective appointments mean that it will come into
Yes,
force after the judgment.
Yes, my lord. Second part, my lord, but will carry the benefit of, my lord, the past service of the purpose of computation of pensionary benefit, my lord. So, my lord, when, my lord, this judgment was passed, my lord, completely, my lord, honorable judge was considering, my lord, old pension, because at that time, my lord, the new pension was not in force, my lord, because this is the judgment of 2003, my lord. But subsequently, my lord, in the year 2005, my lord, new pension came, my lord. And thereafter, my lord, we were regularized one. That apart, my lord, after new pension came into force, my lord, another judgment was passed, my lord. I have annexed, my lord, page 39, my lord. This is, my lord, 2010, my lord. After, my lord, completely after, my lord, the new pension came into force, my lord. But here again, my lord, this Jivan Chandra Deka was reiterated, my lord. But they did not, my lord, oppose, my lord.
In this judgment, whether there is a direction to consider
Yes, my lord.
these incumbents in the OPS.
Yes, my lordship, page 44, kindly have a look. This Jivan Chandra Deka was completely, my lord, quoted in this judgment,
What
my lord,
do you
page
say?
44, my lord.
Lordship may be pleased to admit this appeal at this stage. It will require extensive.
Admit, issue notice.
That the past services can be counted for the giving benefit under the OPS. That is the precise issue.
Admit issue notice, Mr. So and so person appear. You will appear for all respondents?
My lord, I am appearing for respondent number 2, Finance Department.
To respond number 2, Finance Department. Others?
My lord, I appear for response number 1, 3, 5, and 6, education.
1, 3, 5, and 6. 1, 3, 5, and 6. 4. All right, mark the attendances. Thus, as all the respondents are duly represented, notice need not be issued.
Item 21 to apply.
List for hearing.
People,
Obliged.
Matter number
in
14,
due course. Yes. Matter number 13.
May it please your lordship.
Yes.
Malad, at the very initial stage, I say, there was some latches on our part, my lord, bowing down my head, my lord, that I can say, because the council was not present. The grievances, your lordship, the honorable single judge has correctly done it on the basis of the paragraphs laid down, has said the case has become infructuous.
Mm.
Only because, my lord, they have sent the document to the authority to sanction my pay. But my lord, at memo of appeal from page 11 onwards, there are still some calculations because in 15 the judgment was given, they have paid me in 19 along with interest and others which were not paid to us.
Hmm.
My lord, I can, if lordship seeking some indulgence of your lordship gives me a permission to place my case back to the learned single judge once again, my lord. Because some grievances were not there, because the ground taken is this, my lord, that because the petitioner is also not represented, the court closes the instant petition as infructuous.
Hmm.
My lord.
Then we could have filed a review saying that it was not
My lord,
infructuous.
Your lordship gives me authority to file a review, my lord. It's a liberty to file a review, my lord.
Then counsel, Mr. P.K. Roy Chaudhary submits that as the petitioner was not represented before learned single bench, few important issues are required to be adjudicated would not to be brought to the notice of the court, and hence, the petition was closed as infructuous, whereas, some issues raised by the petitioner still remain alive for adjudication. He prays that the petitioner may be permitted to file a review application before the learned single judge. And counsel for the respondent has no objection to this prayer. Thus, leaving the petitioner at liberty to appellant at liberty to move the single bench by way of a review petition, the instant proceedings of this writ appeal are closed.
Obliged.
matter number 16,
May I please, Lordship? Lordship, this is an, I have filed this appeal against the order passed by the learned honorable family court, Lordship.
Yes.
My prayer for divorce was rejected by this honorable court, Lordship. Against this order, I have
Admission notice sent for record. Steps for service be taken within 3 days.
notice has,
Record is there. Notice
notice was issued, Lordship, paper.
When?
I have gone for paper publication also, Lordship.
when? That was on delay condonation, madam. Problem is there. In this appeal, the fresh process has to be started. That
Lordship,
was only for the purpose of delay.
Lordship.
Admission notice. Steps for service be taken within 7 days, whereupon
March,
notice be issued to the respondent.
March.
LCR you need not write. Set.
matter number 18,
My lords, can this matter kindly be taken up after some time? Mr. S. Bhattakur will appear in this matter.
Today you want
Yes,
taken
my
up.
lord.
pass over.
Much obliged.
Also for today.
Pass over for now. Now, time.
matter number 19,
Before I understand starts, my lord, there is a subsequent development after the dismissal of the writ petition. The bank has, my lord,
Bank
Copy may
has-
be also be given to me, madam.
14 to 12/22.
14/12, my lord.
But I have already annexed this.
This is already on record.
I have brought it on record, madam. This appeal is otherwise, my lord, against the judgment of the honorable judgment of the single judge, my lord, whereby my writ petition challenging the demand made by the railway to encash the bank guarantee is under challenge, and also of the concerned bank, my lord, whereby despite that there was no bank guarantee valid on that day, the bank has issued a notice to us to arrange the money. This is the challenge before the learned single judge. However, my lord, this is in relation to a contract for constructing railway line, my lord, the BG lines and embankments, my lord. Now, my lord, what has happened? Once earlier also it was terminated. At that time, they had filed a claim for encashment. Later on, there are a lot of challenges made, and ultimately there is an order from this Honorable High Court, my lord, whereby they were asked to give more time to us. Basically, they agreed and they gave us time to complete the work. Now, at that moment, obviously, all the consequences goes away. It's a deemed determined because whatever termination, whatever steps taken, everything gone away, and they have given us. Accordingly, we kept the BG valid. Ultimately, we couldn't complete, my lord. And finally, the bank guarantee was also expired. And after about 2 years, my lord, from the second termination, suddenly we received this letter, my lord, whereby they
read the findings in the order of the learned single
yes,
judge.
basically dismissed only on the ground that we have not challenged the
Order of
termination.
termination. So
Termination.
the encashment of the bank guarantee is the natural consequence of termination.
Absolutely, my lord. But here, my lord, determination is an independent cause of action and bank guarantee is another cause of action because that would depend on the terms and conditions of the bank guarantee. Now, that has not been gone into.
So that would be
My only
dependent on the
limited
terms and
grievance-
condition of the contracts, Mr. Counsel.
My lord, here.
For the bank guarantee, the contract would be
True, my lord,
the-
but your lordship,
governing factor.
Sri Lanka, Vidyarthi, Ramsham's case, my lord, here there is an illegality, my lord. I am only saying that this is not legally enforceable. So they cannot insist us. Now they're harassing us after 2 years. That is what I am before your lordship. My lord, I'm not troubling today your lordship with any stay, my lord. Your lordship may examine the matter because the only ground on which the single judge have dismissed because I have not filed it, I have not challenged the termination. I am not on that, my lord. My case is only on the bank guarantee. In fact, your lordship will kindly see the performance clause 36 of the contract, which is at page 65. Just for a moment, my lord, for my satisfaction.
Just hold on.
The contract starts at page 65.
Who represents the railways?
My lord.
You are for the railways?
Yes, my lord.
All right, tell us, what about this argument that there was no valid bank guarantee on the date you requested for the forfeiture thereof? How there can be a forfeiture?
My lord, initially when the bank guarantee was in force, my lord, the railways have applied to the bank for invocation in time, but a writ petition was preferred by.
All right, by that, by virtue of that order, that irregularity stand purged.
My lord, there was a stay order by this court by which the bank invocation was stayed.
Presuming that, sir,
My lord, we applied to the bank in time.
contract was thereafter terminated in 19th. You woke up after 2 years.
No, my lord, we have been writing, there was a stay order, my lord, until.
Operational till,
My lord, this representation.
just show us the date, tell us the dates, please.
My lord.
Stay order was operative till when?
I will.
Well, this stay was given to the
28th
first
9,
encashment and
2022,
it
my lord.
was
Just hold on, Mr. Goswami. You can have your seat.
My lord, the stay order was, the stay order got vacated on 28/9/2022.
22.
Yes. So, my lord, from the period.
Stay was passed in this writ petition only.
No, my lord, that is what I was trying to clarify.
There was another writ petition, my lord. They have filed another writ petition wherein the invocation of the bank guarantee was stayed. And my lord, from the period, my lord, 10/8/2018 till the order was vacated on 28/9/22.
Yes.
The invocation of bank guarantee was stayed and we could not invoke because of the stay orders of the honorable court. The moment the stay orders were vacated, my lord, we approached the bank and the bank has rightly, the communication which I have given, my lord, has demanded them to.
Ask them to furnish the bank guarantee.
Furnish the bank
Fresh.
guarantee.
That is the very issue involved.
And the.
Whether they can be directed to furnish a fresh bank guarantee.
No, my lord, the same bank guarantee they are asked to.
That bank guarantee is the term is, the life is over. What was the validity period of the bank guarantee?
My lord, we have invoked in time within 90 days.
Understood?
My lord, within
Understood.
90 days,
For
but there was a
XY
stay order.
It is a banking transaction, banking
Well-
document. It has its own life.
My lord.
Simply because you applied in the correct, at the correct point of time.
My lord,
Can
it
we,
was-
can we give any direction of extension of the bank guarantee, which has lapsed?
My lord, it cannot be said to be
File a
lapsed
civil
because there
suit.
was a stay order by this.
File
court.
a civil suit.
My lord, there was a stay order by this court.
All right. You should have asked the court when the writ petition was disposed of as
And that
infructuous.
petition was dismissed for default. They have.
You should have asked the court that please give a direction for extension of bank guarantee
And
because
my
they
lord-
are at fault.
And my lord, under the terms of the contract.
One more thing,
said-
sir.
My lord,
Your contract was terminated. His contract was terminated in 19. Why didn't you inform the writ court for 2 good years that the contract has been terminated? Please dismiss the writ petition.
and my
Why
lord,
were you sleeping?
but my lord, any my lord, interference. my lord,
Tell us any judgment by virtue whereof or any law.
And my lord,
The
it is-
court can give a direction or the bank can give a direction to the customer to renew the bank guarantee which has lapsed by a flux of time. There is no privity of contract between the bank and the customer so far as this contract is concerned.
my lord, in my humble submission, my lord, since the bank, the railways
It's
have
the open
approached.
and shut case. Railway says, I want invocation of the bank guarantee. The bank will say there is no bank guarantee as of
The
now.
bank has agreed to pay, bank has issued direction to pay. my lord.
Is there a valid
That
bank
was not
guarantee?
under Challenge.
Yes, Ms. Ganguly.
That was not under challenge.
Yes,
Communicated to the railways, as on date, no liability.
there is no bank guarantee, no liability.
There is no question of invocation. Unless and until they readily come forward and extend one or create a new one.
Yes,
My lord, the communication says otherwise, my lord. The communication
Re-
says we therefore demand the payment of bank guarantee.
so bank guarantee. Are you sure?
My lord,
read
the
it
payment
again.
of performance bank guarantee.
Make arrangements.
No, my lord, my lord, the communication which I have given,
Yes, read.
I will read, my lord. In connection with your BG numbers, so and so was issued on 29/2017 lieu of BG bond number so and so. We point out that in NF Railway wide letter dated 25/11/22 for encashment of bank guarantee, bond number so and so was issued on 29/2017.
Gentlemen, if the bank guarantee was live, what was the reason for the bank to write this letter to the customer? They could straight have said, all right, this is encashed. This is invoked.
There was a stay order.
Stay has been vacated.
Thereafter, we have written to
So,
the.
all right, why does the bank is required to write to the customer? The bank guarantee is there in favor of the.
No, we have written, no, we have written a letter, my lord. We subsequent to the dismissal of the writ petition,
Yes,
it is pursuant to our communication.
for invocation.
My
You
lord.
just now heard, Mr. Ganguly, that on the date you wrote the letter, there was no live bank guarantee with them. What was the tenure of the bank guarantee?
90 days, my lord.
Finished 90 days from 2017.
No, my lord, it was, it was last extended up to, my lord, 31/3/2019. The bank guarantee was
And
last.
you sought invocation in 2022,
No, my lord. we have-
November.
We have sought in time, my lord.
So,
The-
sir, you
in
were
between
required,
that, my lord, there was
you
a
were
stay order.
required to tell the writ court, sir, please, while you are dismissing the writ petition, give a direction for extension of the bank guarantee. That is what, that order is not before us. Is it
That
right?
was not the subject matter also, my lord. The, before the learned single judge.
You say,
The,
not this writ petition, the earlier one,
my lord,
which was dismissed for want of prosecution.
my lord.
In that, the bank guarantee was stayed,
Yes,
invocation was stayed.
my lord, my lord.
So when the writ petition was being disposed of, you should have made a prayer. Even now, go and file a review, file a clarification, get an order of extension. The bank guarantee will become
My
live.
lord, but, my lord, as per the terms of the contract, my lord, it is the duty of the contractor, my lord, will see page 90.
Supposing he does not perform his duties, what is the remedy available?
Because, my lord, any
Is there an
direction,
arbitration clause?
because that amount has to be recovered, my lord, because the contract is
So
not.
he's assuming that the bank guarantee lapsed, there was no
They
stay.
have not challenged the
Just
termination.
hold on, sir.
my lord.
There was no stay and the bank guarantee lapsed. What is the mode with the railways to recover the amount? What is the procedure?
Money, we will have to file a civil.
Suit.
That will have to file a.
That is what the remedy is now even.
But, my lord, any order by the honorable court, my lord, may
Gentlemen,
affect
you-
our right before the
You
civil
do-
court.
Why do you want us to repeat continuously?
My lord.
Do you understand what we are trying to tell you? That you did not seek any extension in the writ court.
That is,
He gets advantage of that. Now, what authority does the bank have? Tell us under the contract that if the bank guarantee is even lapsed, the railway can seek a direction that the party should be asked to
my
renew
lord,
it.
page 92, my lord, will take.
Yes,
for a moment,
read.
my lord, the terms of the contract,
92.
page 92. The engineer shall not make a claim under performance guarantee except for which the President of India is entitled under the contract, notwithstanding an oblique or prejudice to any other provisions in the contract agreement in the event of failure by the contractor to extend the validity of the performance guarantee described herein above, in which event the engineer may claim the full amount.
Claim. Claim by what mode? Claim by what
That
mode?
we are pursuing, my lord, money suit, the department is pursuing.
Only
to
there
file.
the remedy lies. All right, we'll
But-
admit the,
My lord,
admit issue notice.
my lord,
You represent
1 to 7. my lord.
responsibles 1 to 7. Mr. Ganguly appears for the spot number 8. Thus, notice need not be issued. List for hearing.
Deeply obliged, my lord.
Number 20.
May I please? My lord, the commissioner approached this honorable court, my lord, challenging his order of cancellation of his appointment, my lord. He was regularly appointed, my lord, pursuant to regular selection. But what happened, my lord, subsequently, the authority has detected that the petitioner does not fulfill the condition as per their rule, my lord, state rule. But he fulfills the condition as per the NCT norms, my lord. And therefore, he approached this honorable court, my lord. And this honorable single judge, my lord, while deciding the issue, has observed that as the other candidates like similarly situated like petitioners were not participant would be deprived of, so his case cannot be considered. But my lord, we have made a statement, my lord, that the similarly situated candidates like petitioners have participated in the selection process. That record was not asked for while deciding the issue, my lord. And moreover, my lord, this earlier writ petition was remanded by this division bench. It was listed before the division bench, and division bench remanded, my lord, by order dated 28/4/2022.
Sir, simple question is, were you having the requisite number of aggregate marks in terms of the recruitment notification?
I'm having the record as per the NCT norms, my lord.
As per the recruitment notification. If you're not happy with the condition, you're required to challenge it before participating.
I have challenged the rule, my lord.
Before participating.
It is-
Having participated, you can't.
I have been appointed, my lord, regularly.
Yes, wrongly appointed. The appointment order always contains a condition. It is provisional. And it is liable to be set aside at any point of time.
Other, my lord, other.
Mr. Mazumdar, we'll admit it, he has an arguable issue, but will not stay.
Alias, there was stay orders, my lord, in the single bench, my lord.
There was a stay.
Yes, sir.
And he has a point to argue. It was an error on your part. And if he says that he's eligible under the NCT norms, why not continue him? Duly qualified candidate, removing him after 5 years of service. Though, of course, you see that judgment Alka Oja. Therein the candidates who were wrongly appointed, they were removed from service after 5 years. How do you get by that judgment? Tell us tomorrow. Take out Alka Oja. You have an idea about the judgment? Search Alka Oja. That was a case of almost on similar facts.
NCT actually lays down the minimum norms. We had our own recruitment rules putting a higher standard on
Did
it.
you have sufficient number of candidates? Then?
Yes, my lord, all the posts are filled up. There's no difficulty.
My lord, candidates like the similarly situated like the petitioners who
Give an
fulfill the NCT norms, my lord, they all them participated in the selection process.
Mm.
And in the same school, my lord, like me, another 3 candidates were there. But I was top in the, therefore I was selected, my lord. That was the actual position. But so it is not the fact that I was only.
Read the judgment and come.
I will.
Halka ho jaye. How do you get by the law as laid down in that judgment? List after tomorrow.
Bless me.
Bless you.
Item number 21.
My case is, may please, your lordship, my case is same as item number
Item number.
13, my lord, 13. Your lordship has already admitted.
Agreed by the common judgment and
Mal.
order.
Item number 13.
13.
So we'll admit that,
Smile.
admit the respondents are represented as so and so by so and so. Thus notice need not be issued. Connect with writ appeal number so and so. 156/23.
My lord.
My lord.
God bless.
Item number 23.
This is against the auction notice. The page 14 is the auction notice.
Why is this writ to be entertained, sir? Southern Valley judgment.
Just I want my prayer is only 6 months. If it's given, I can return the.
Read the judgment, please. South Indian Bank. Read for how Supreme Court has dealt with the High Courts. Proceedings are statutory remedy of appeal. Approach the DRT.
Yes.
Dismissed. What has happened to the streaming?
Item number 24.
My lord, kindly pass over the matter for the day, my lord. Already we have filed an adjournment petition, my lord, from our side, my lord.
Appellant's counsel, petitioner's counsel has circulated an adjournment slip. What is the matter in about? What is the petition about? Mr. Nayak?
In this PI, lordship, he, on the basis of CAG report, lordship, he is claiming for some high level inquiry, lordship. And in the affidavit, we have filed our affidavit, lordship. Then we have stated that at the time of filing of the affidavit, lordship, initially there were 21 numbers of allegations or observations made by the CAG, lordship. At the time of filing this affidavit, lordship, already 8 of them has been dropped, lordship. So it is a
Still
continuous.
13 would remain.
Yes, it's a continuous process, lordship, and this is not a final type of thing, lordship. It's in the correspondence, they are satisfied.
Counsel, the petitioner circulated an adjournment slip, list up 4 weeks as per.
Obliged.
Item number 25.
Yeah, please, your lordship. Lordship, in this matter, the union government was supposed to file their affidavit. They have not filed their affidavit as of now.
If the lordship will see the prayer, lordship, here is a case where the petitioner seek ration cards.
Ration cards.
Ration cards, and this case particularly was filed during the height of the COVID. That time there was some shortage of food. That situation does not exist as on date.
But why not complete the process of issuance of ration
Ration
cards?
card, lordship, they have to apply. They-
Citizenship is the issue.
And
They are not
What do you say? If the petitioners don't apply, this was basically during COVID you filed.
Yes, yes.
Now those issues do not survive.
And my lord, the other is they are non-citizens, man. And
They are non-citizens.
Yeah, applications are pending with the Ministry of Home Affairs.
So how can we give that direction?
Issue, my senior will be the best person to assist.
Under the
this
NHS,
matter.
my lord, it is-
That's right.
Otherwise, we are giving them food grains announcement, even continuing, and up to the status reports are also here. We have filed everything.
And additional Advocate General Mr. Goswami submits that appropriate quantity of food grains is being provided
Yes.
to the petitioners
In 3 districts, my lord.
in petitioners and other eligible persons. Similarly placed persons in 3 districts of Arunachal Pradesh, namely
Papumpare,
Papumpare,
Namsa, and
Namsai and Sangha. The council for the petitioner pays for time to complete his instructions. List up 4 weeks. Or 6 weeks.
So direction maybe issued to the central government to file.
In the meantime, Kumar, the deputy SGI
It's there, but
file a formal affidavit. Mr. Chaudhary shall file the affidavit on behalf of the government of Union of India. 6 weeks.
Matter number 26,
Deeply obliged.
Please, Your Lordship, I am for the appellant in this case. Yes.
This arises out of disciplinary proceedings.
Yes, Your Lord.
Yes. So what do you want? You want an adjournment?
Yes, Your Lordship. On the last day, it was directed by this honorable court that they should furnish the statement of witnesses, but
Hmm.
when they haven't furnished it.
The statements of witnesses
Yes, Your Lord.
as directed by order dated 19/4/2023, statements, copy of the statements of witnesses have been provided to the land council representing the appellants. List the matter. Appellants who prays for 4 weeks time to complete his instructions. List of 4 weeks.
matter number 29,
My lord, here, my lord, the respondent was supposed to file affidavit by the Karbi Anglong Autonomous County. my lord.
Hmm.
We have filed the affidavit today, my lord, and we have served a copy to the petitioner and the governor advocate also. It is not in the record, my lord. Let it be listed along with the record and they may file the rejoinder.
Affidavit as all land council representing the KAC has response number 6, 7, 11 and 12.
7, on behalf of 7.
Only respond number 7 has filed affidavit on its behalf. Today, the same be brought on record. Petitioners council may file a response there to, if so required. List after 4 weeks.
List.
matter number 30 to 32.
Yes.
Your Lordship, in PIL 52, we are ready with the affidavit. Just in the due course of time, we will be filing today only.
All right.
But in PIL 6, I was directed to obtain the minutes of the SLRC, madam, State Level Police Recruitment Board.
Yes.
That copy I received yesterday, madam.
Yesterday.
Yeah.
Okay. So provided to the petitioner
Yes, madam. The kindly see the serial number 10.
10.
Not yet. But if some clerk or some junior is available here, madam, I can give a copy right now, madam.
All right. They have provided us the minutes of the meeting wherein it has been resolved that provision will be made for the TG category in the application forms for the upcoming recruitments. That is what they have indicated. We'll forward the copy thereof to you. If you want to respond, do it by next day.
Fine,
Ms.
fine, Your Lordship.
Swati,
Your
do-
Lordship, Your
Yes.
Lordship, pertaining to PIL number 2,
Yes.
I have received the affidavit and Your Lordship may just see page 100
Can
of
we,
the
can we,
additional.
just hold on. Can we please pass the orders in 52 and 6? In
Yes,
50
yes, Your Lordship.
Council Swati Barua representing the petitioner has submits that she shall be filing, that the affidavit on behalf of the petitioner will be filed during the course of the day. First up, copy thereof shall be provided to the counsel, all counsel representing the respondents who may submit response if so desired by the next date. Date will fix there thereafter. In PL 6, Mr. Nath has placed on record copy of the minutes of meeting dated 22nd October 21. After that, you have not made any recruitments.
Well, in fact, in the affidavit, we have taken a stand. In that particular advertisement or person to that advertisement, no transgender person has taken part. That was the instruction.
You did not indicate a specific category. That is what their grievance is.
Yes, yes. That's
These are minutes of meeting held on 22nd October 21.
possibly not, Malad. Then let them respond, Malad. I'll in the meantime get the instruction.
He submits has placed on record copy of the minutes of SLPRB meeting held on 22nd 10/21. The petitioner's counsel prays for time to go through the contents of the minutes and to respond thereto if so desired. Now, all right, in PIL 2.
In PIL 2, your lordship, I have received the additional affidavit in opposition. And your lordship, I will just pray and request to pursue page 100 of that same.
Just. Respond number 4. Yes, page 100. Read.
Page 100, paragraph number D. And it goes with an office room for the Transgender Welfare Board to be allotted at the shelter home for transgender Tritiya Nivas, run by NGO named Northeast Voluntary Association of Rural Development. Your lordship, this is fine that the government is now is in the verge to allot us a room to execute the functions of the Transgender Welfare Board.
Yes.
At the same time, as per the information that was provided by the government, 6 lakhs has already been sanctioned. But till date, we haven't seen a single inch of any initiatives that has been taken in this regard. Neither we have seen any office, neither where the 6 lakh has gone, or whether it is used or not used, we don't know.
Where is the 6 lakhs referred to? Is there any reference to the 6 lakhs or sanctioning of budget?
That is what on the last day the learned council has made a
Yes,
submission.
let the council respond. Yes.
Lordship, 6 lakhs have been approved, but the ceiling and sanction of the proposal is not given by the government, Lordship. As soon as it is given, we can release it.
Why it has not been given? Finance is sitting right on that. And what about the room? Has the room been identified?
That instruction I don't have, Lordship.
So the affidavit says so.
Lordship.
You are appealing for the respond number 4.
Yes, Lordship.
So I'll ask your officer to be here in the next.
No, Lordship, it has been identified because we have stated in an office room of the transgender welfare, it will be given in the Tritiya Nivas. It has been identified, Lordship.
Who will give the response to the budget part?
Budget part.
Finance. All right, we'll implement finance in this then. And council representing the respond number 4 submits that a room has been identified in the Tritiya Nivas run by NGO Nivard for setting up the office of the Transgender Welfare Board. He further states that a fund of rupees 6 lakhs has been sanctioned for furnishing an operations part of the office, but till date, the matter is stuck with the finance department. We hereby direct Learned Counsel Mr. P. Nayak, Standing Counsel Finance Department, to take instructions in this regard and ensure that the budget so sanctioned is released at the earliest. The respond number 4 shall ensure that the office of the board is made functional positively by the next date of listing. re-notify on 24th June. In the meantime, we expect that the things should move.
Yes, yes, your lordship.
24th June.
So all will come on 26th, 24th June. Name of Mr. P. Nayak shall henceforth be reflected as counsel for the respondent for finance department in writ petition number PL number 2/22.
Lordship, 24th June is a Saturday, Lord.
All right, 23rd June. Mr. Nath, ask Mr. Nayak to take instructions
I'll-
accordingly, or he may take a copy of the order.
Lordship.
Copy of this order shall be provided to Mr. Nayak forthwith.
Obliged, your lordship.
Yes.
Your lordship, I may be permitted to leave.
Yes, yes.
Obliged.
Matter number 34 of supplementary list.
Lordship, this matter relates to shifting of two Gaon Panchayat, Lordship, from jurisdiction of Lakhimpur district to Dhemaji district, Lordship. Lordship, my contention was that section 5(2) of the Panchayat Act was not being followed while the shifting of that Gaon Panchayat was undertaken, Lordship.
All right.
Lordship,
Assam Panchayat Act. 5(2). Let's see. What is the requirement?
Lordship, there needs to be one consultation with the Gaon Panchayat. before-
Consultation. This is held. Similar provision has been held to be directory by Rajasthan High Court. Division bench. Exactly similar provision. Where is the order?
Lordship, the order, Lordship, as such, shifting was initiated, but Lordship, no order was passed for shifting, Lordship.
Then
It was initiated, Lordship will find it at page 16 of the petition, Lordship, by way of this, in this manner, Lordship.
it was initiated. Is it stayed? The process has been stayed.
Yes, Lordship.
What do you say? Why don't you reconsider the things now? That is why we had posted it today.
Lordship.
It's now 7 years down the line, 8 years.
I am representing, my lord, private respondent, my lord, implemented respondent, my lord. I want the matter to be remanded back to the authority, my lord. They will take the.
What is the state stand?
Yes. And that the interim order to be vacated, my lord.
Interim order will be made absolute. And then the state government may reconsider.
They come to their prayers, my lord.
Hmm. Where is the order? Ultimately, there is no order. Has been.
No order.
So if at all you want to undertake this exercise, do it as in accordance with section 5.
Yes, ma'am.
That's all. The petitioner herein has filed the instant PIL questioning the impugned action, public decision of the state in transferring 5 Gram Panchayats, including so and so, from the administrative control of Lakhimpur district to Dhemaji district. Full stop. In order to fortify its challenge, the petitioner has placed on record, copy of the communication dated 13/7/2015, whereby, a meeting was convened in the office of the Deputy Commissioner Lakhimpur on 13/7 to consider the transfer of the administrative control of 6 Gram Panchayats. First off, the PIL came to be filed in the year 2016. The order passed by the further proceedings pertaining to the transfer of administrative control of these Gram Panchayats was stayed by this court on 6 by order dated 6/10/2016. Manifestly, thus, there has been no final decision on this aspect till date. No final decision has been taken on this aspect till date. The Petitioners Council drew the court's attention to the provisions contained in section 5(2) of the Assam Panchayat Act and urged that any decision to transfer or change the boundaries of a panchayat is required to be taken after consultation with the Gram Panchayat concerned. He urges that as no consultation has been made till date, the impugned action is bad in the eyes of law. Then Government Council, Mr. Swanchu submits that as a period of more than 7 years, 8 years has lapsed from the date the excise was initiated, it would be opposite if the matter is remanded to the concerned authorities to take an objective decision, fresh objective decision regarding change of boundaries, public administrative control of the panchayats concerned, keeping in view the facts and circumstances prevailing as on date and after due consultation with all concerned parties in accordance with the provisions of Panchayat Act. Accordingly, the instant writ petition is disposed of, requiring the competent authorities to undertake the exercise of changing the administrative control of the panchayats, Gaon panchayats concerned, within bracket, if so desired, bracket close, after due adherence to the requirements of section 5 of the Panchayat Act. Needless to say that all concerned parties shall be consulted before such a decision is taken.
Lordship, somewhere it might have gone as 6 Gaon Panchayat, Lordship. It should be 4 Gaon Panchayat along with 6 village of Dhupana Gaon Panchayat.
4 Gaon Panchayats and 6 villages of Sarns.
Obliged, Lord.
Item number 18 passed over.
No order is to pass. 18.
May I please, Your Lordship? The petitioner has filed this present PI, Your Lordship, praying for a issuance of the writ of quo warranto, Your Lordship.
Appointment of as a Vice Chancellor.
Lordship. Now, Your Lordship, our case is that, my case is that, Your Lordship, is the selection of the particular, Your Lordship, respondent, Your Lordship, the Vice Chancellor is not per the UGC guideline, Your Lordship. The search committee that has been constituted under section 19 of the Assam Agriculture.
Why are you aggrieved?
Aggrieved, Your Lordship, so far as this issue is concerned, Your Lordship, since he has usurped an office, Your Lordship, a public office, Your Lordship. As a citizen, Your Lordship, I am an aggrieved person, Your Lordship. I don't have any other, Your Lordship,
interest in this.
Interest in this.
All right, we'll put the other side to notice then.
Lords.
Third, issue notice to the respondents. You appear for
I'm for the University Grants Commission.
Mr.
Number 4, Miller.
So puts an appearance on behalf of the respondent number 4, UGC.
Yes.
For 2, Madam so puts an appearance on behalf of the respondent number 2. Secretary, Department of Agriculture. Union of India, mark the attendance of Land Council. Thus, process be issued upon who will be appearing for Department of Agriculture. State, we understand. They have a separate. All right, the steps for service upon the remaining respondents be taken within 3 days, whereupon fresh process be issued to them. Thus the service, thus the service is permitted. Rule is very determined 4 weeks. Take a few lines on the top. Third, the petitioner through this petitioner in this PIL petition, calls into question appointment of the respondent number 6 as Vice Chancellor of so and so university on the ground that the appointment so made is contrary to the UGC guidelines. Then you pass that on.
Deeply obliged.
Yes.
Matter numbers 35 to 47, pardon matter.
What is it? Arshindra Varishaw. Yes. What, how will you proceed?
My lord, I would like to clarify three issues before I go into Arsinda Varisa, because the hearing was done with all the accused persons. The first issue yesterday, your lordship has raised regarding the joint trial.
We have not raised any issue.
My lord, that
It's
the
just a
order,
query.
query.
Yes.
See, your lordship will find that order. What happened on 19/10/2010? I have given the list of dates. Yes, I got the list of dates.
The trials may have been taken up parallelly, but they were never joined.
My lord.
There was never a joining of trials. They have been virtually tried as two cross cases are tried.
My lord.
Trials go on together, judgments are separately passed.
What happened on 19/10/2010? NIA IO, Investigation Agencies IO Asia's Kamyal, he filed an application before the trial court, the special court, for joint trial of NIA 19 and 29. So what the reason was that all the accused
Witnesses were common, accused were common.
accused were common except Jivangshu Paul, which is, my lord, the learned trial court, special court, has passed two orders on two occasions. First order was passed in 4 December 2012, where the pair of the IO was rejected. Now, subsequently, my lord, again, without any application of the NIA, that the court proceeded with the joint trial on 1/8/2013.
What is the order we like?
My lord, I will take you to the order.
Before that, some witnesses must have been examined.
But some witnesses were examined.
So there is no question of a joint trial then. Loosely termed, it may have been a joint trial. Joint examination of the witnesses
Yes,
for
my
both
lord.
cases is all right.
Like, for example, my lord, PW 1 in 19,
If it was a joint trial, there was required to be a common judgment.
common judgment.
So there is no common judgment.
No
So
common.
there is no joint trial.
No. Your lordship, second issue, your lordship.
Anyhow, do you have a copy of that order?
My lord, I have.
Let's see. You provided it in the list of dates?
My lord, it has been there in the list of dates. I have provided.
No, copy of the order.
Copy of the order. Sorry, my lord, I did not provide, but
Let us have a look at it.
may I read it, your lordship? Perused 4/12/2010, my lord. The rejection order, your lordship, that the joint trial order as per the learned trial court.
Yes.
The rejection order is, my lord, it reads at 4/12/2010. Perus petition number 2302 of 2010 dated 19/10/2010 filed by Mr. K.S. Thakur, DSP Police IO NIA New Delhi with a prayer for joint trial of NIA case 19 and 29. Seen also the written objection filed by learned advocate for the accused Jayanta Kumar Ghosh, white petition number 2342 of 2010 against petition number 2302 of 2010 dated 19/10/2010 against joint trial. Seen also the written objection filed by learned advocate for the accused RS Khan, white petition number 234110 in response to the petition filed by the prosecution for joint trial of NIA case number 1 of 2009 and 2 of 2009. Seen also petition number 249610 dated 2011/2010 along with the objection filed by learned advocate for accused A. Warisha, Joel Garlosa, Niranjan Huza and Samir Ahmed against the petition for prosecution of joint trial. In petition 2342, learned counsel for the accused Jayanta Kumar Ghosh and others stated that Sri Dolan Gapu, who is a witness in NIA case 19, has subsequently made accused in NIA case 29, and that will create difficult to try both the cases together. It is further contended that the investigating agents authority has tried to use the evidence of NIA case 19 in NIA case 29, and for that reason they prayed for joint trial of both the cases, which is not permissible in the eye of law, and accordingly prays for dismissal of the petition filed by the prosecution. The learned counsel for accused RS Khan, by filing their written objection, contended inter alia.
Come to the conclusion, please.
My lord. Now, as per FI of NIA case 29, it appears that on 11/2/2009 at 3:30 during checking number AS 85138 Taijuari boarded
bordered by Golan Dalagapu, NCSC Autonomous Council and Sri Jivangsu Paul recovered cash of rupees 32 lakhs 11,000 from the possession of Sri Jivangsu Paul. And they could not give any satisfactory reply on account of carrying such a huge amount with them. And it is alleged that both the accused person carried the said amount to hand it over to DSDJ extremists. But as per FIR of NIA 19, it reveals that on specific information on 1/4/2009 at about
Just hold on. The FIR of 2 is dated 1st February, February 2009.
February 2009.
And this is subsequently registered.
My lord, no. The FIR of NIA 2 of 2009, it
You read the date as February.
11 February 2009,
So that was registered earlier.
earlier,
And still NIA 2 was.
subsequent. Our NIA 19 is 1st April, my lord.
That's what we are.
At around 4 PM, while AS01, AS1422 and AS01 L0690 Tata Sumo were intercepted.
Please read the reasoning.
My lord, reasoning is, that is only the it operates, my lord. It appears that both the alleged offences were not committed in the course of same transaction, and as such, the vital ingredient which is necessary for joint trial in this instant case is lacking. It is an admitted position of fact that the accused Dolan Gafu is a witness of NIA 19.
All right, you give us the order of 13. Let us read. Here's the order.
Order of
2013, whereby you say that joint trial was.
Yes, my lord.
You pass it on. Give it.
My lord. Sir.
Oh.
This order is passed in NIA case 2 of 2009. One. 161.
Okay. Then, yes. Strange.
My lord, in the argument stage, in the trial, in the argument stage, we raised this issue that if we see on the face of the order, yes, it is correct. It was not a joint trial because PW1 is one case and there. So by the prima facie, which we see, it implies that it is a joint trial and it amounts like a review of the order. Earlier order by the special court saying, which is not permissible in the court, my lord.
But be that so, the London trial court did not reflect it in anything in that order sheet, and there are two separate judgments, Lordship. But since your Lordship has raised this, because your Lordship.
There are separate judgments. So all these accused who have filed appeal in one,
Yes,
they have also been convicted in two.
no,
For the reason that the trial court, this order of 2013 reflects that they were discharged from two on the ground that they can't face trial in two cases.
Two cases.
On same allegation.
Same allegation.
Hmm.
Same allegation.
All right.
My lord, second, your Lordship, as yesterday, wanted to know about that contradicting part, Amitabh Sinha's aspect. And your Lordship, before your Lordship was putting a query to all of us, even to our Mr. Learned Senior Counsel also, that how we contradict a witness, that there is a Tehsildar's judgment is there, 1959. Your Lordship there, and my senior also referred to the state of Rajasthan versus Kashmir Singh, Qatar Singh. Your Lordship, the point which your Lordship wanted to refer, that how do we mark it? My lord, that has been settled by this honorable court 3 decades back. Exactly on that point, my lord. I will just put these two judgments, my lord. One is 1963 SCC online Guwahati.
And what happened? These judgments went into hibernation or what?
My lord, don't know. As your Lordship was putting a query yesterday, that normally the trial court, it is followed in Assam, but that's not the case, my lord. This has been settled by the 4 decades before.
That's why we are commenting that these judgments, the ratio seems to have gone into hibernation.
But there must be a flaw in both of our part, prosecution and defense, I must say.
Of course.
But the trial court should have looked into those things.
You're right.
Trial court should have
Ultimately, the master of trial is the court.
My lord.
Ultimately, the proceedings are in the language of the court.
My lord, even I found one judgment that if in a cross-examination, if the defense counsel is not able to put
165.
Yes, the trial court can.
Trial court is not to be act as a bystander.
Yes, my lord.
There has to be active
My
participation.
lord, kindly look to these two judgments, my lord.
Right.
Yes, your Lordship may take up this paper book. I have annexed it.
Yes.
At page 162.
Yes.
State versus
I have
Mishra.
given both the judgments are there.
Sir, Ganakanta das was niki?
Yes. Page 162.
My lord will kindly come. State versus Misir Ali. Your Lordship will kindly come to para 18.
17.
Para 18.
In Manupatra, it will be 17,
My lord. We had occasion to point out the correct procedure more than once, and it would be worthwhile restating it. If it is intended by an accused to contradict the evidence given by a prosecution witness at the trial with a statement made by him before the police during the investigation, the correct thing to do is to draw the attention of the witness to that part of the contradictory statement which he made before the police and question him whether he did it in fact make that statement. If the witness
there was no need of the judgment, Mr. Borgoin. This section is very clear.
My lord.
Attention drawn to there are two parts. If it is admitted, there is no dispute, it forms a part of evidence. If the contradiction is, the witness's attention is drawn to the contradiction.
My lord.
He admits it, then it becomes a part of the evidence.
My lord.
If he denies it, then it has to be put in the court. To put something in the court is little meaning is exhibited.
My lord.
So mark an exhibit.
My lord, that mark and exhibit part, your lordship, that comes in Ghanakanta's case, my lord.
No, it is there in Misir Ali also.
Misir Ali also, but in Ghanakanta's
If on the other end, the witness, that is the second part of 145.
My lord.
The witness denies having made such a statement. The particular portion of the statement recorded should be provisionally marked for identification.
Yes.
That is exhibited. Mark A to B. I did not give the portion mark A to B of my previous statement, exhibit so and so.
My lord.
That's how it is to be.
Your lordship, that's why on the what I was trying to
Even a novice counsel in Rajasthan, while conducting the trial, would do this, would adopt this procedure.
My lord.
It is ingrained into the system.
145, my lord. No, your lordship was raising this issue that where do we find that particular marking position? That your lordship will find it is explicitly stated in Ganakanta Das case at para 22.
Yes.
My lord, if I read it, my lord, just
2-3 lines. However, if on the other hand, para 22. However, if on the other hand, the witness denies to have made such statement before the police,
Yes.
before the police, the
Yes.
particular portion of the statement recorded should be previously marked for identification as B1 to B1, B2 to B2.
Yes.
Your Lordship, I was looking at that earlier proceedings. Definitely, that's why I was telling that live proceeding recording is very beneficial, which Your Lordship was referring to your Rajasthan's case, my Lord, your own trial regarding that. So this particular aspect, I got it on my Woodruff and Amir Ali, my Lord. So I tried to got it before Your Lordship. That this is the procedure. And surprisingly, my Lord,
145 is very clear.
my Lord,
First part is without drawing the attention to the writing. So the prosecutor or the counsel cross-examining orally puts him the question. You see, you had said so in the police,
my Lord.
in your previous statement. If he admits, well and good, that is an admission. It is recorded as an admission. But if he denies, then that part must be, his attention must be before the writing can be proved. So there are two parts.
My Lord.
Proving of the writing.
My Lord.
How is the writing to be proved? By marking an exhibit.
Exhibit.
Simple as that.
And Your Lordship, when I was going through these judgments, subsequently I found that whether it is in our presently, Your Lordship, I don't know whether this is a correct thing to put it in this manner or not. So I may be with my folded hands. When the trial was conducted, my Lord, there may be flaws in both in the prosecution and defense. As Your Lordship has rightly pointed out, the law says the trial court should look into it.
I'm sorry. Should I take you for 10 minutes?
Sure.
The trial court should look into it. Now, what happened, Your Lordship? If a particular procedure is not followed, it is the onerous duty on the part of the prosecution and both the defense to show it. Now, Your Lordship, I find that recently it has been reported in live law, a judgment passed by this Honorable Court in Criminal Appeal 2005 of 2019. Your Lordship, the author of the judgment, the bench presided, my Lord, happens to be the same Honorable Judge. That I was shocked, my Lord, and I was thinking, whether
the author recorded these statements. Is it
But-
right?
my Lord, you kindly come, Your Lordship will see.
Yes. You see, the author might have delivered the judgment, but not necessarily he recorded the evidence.
My Lord.
It's quite possible that the previous officer might have recorded the evidence.
No, my Lord, this particular matter, though it might be recorded by a previous officer, when you pass a judgment, you have to apply the facts in everything.
You are talking about the manner in which appreciation has been done.
Yes, my Lord.
All right.
So
You
this
see,
judgment is also
now the position is different.
I'm just
Is-
putting in view.
Now, the honorable judge is adorning the bench. You
My
see,
lord.
it's a different position.
Different position. Oops. Now, this is the two things which I like to point it out. I don't know whether it is the correct way to do it or not, but being an officer of the court, I'm bringing the facts clear.
All right. You see, we become wiser by time.
My lord.
So that is the case.
Yes, my lord. My lord, as far as I am Partho Varisa, Arsingdar. Your lordship, I was arrested on 3rd 6, 2000, means 3rd June 2009.
Coming out. Yes. You were arrested on
3rd 6, 3rd June 2009 at Bangalore, my lord. I was apprehended with Joel Carlosa and one of other co-accused, Samiram, who's been convicted. My lord. Now, your lordship, kindly come to the charge sheet. The allegation made against me in the charge sheet by the NIA. There are 6 allegations, my lord. It starts from para 17.14 to para 17.18 in the charge sheet.
Read.
May I, if I read it, or should I come with the points? What is that?
As you desire.
What the main allegation from the charge sheet, if your lordship will refer it from 17.14 to 17.18, was that First allegation is that I was arrested from Bangalore,
Mr. Burgoyne,
my lord,
all of you have been referring to charge sheet right, left and center.
my lord.
Again, we'd like to remind you, charge sheet is not a substantive piece of, it is not a piece of evidence.
Not a
It
piece
is
of-
the opinion of the investigating
My
officer.
lord.
So it has no relevance whatsoever in the trial. We proceed on substantive evidence. Charge is a relevant thing which you can state. But referring to the charge sheet time and again,
My lord, why,
absolutely of no use.
lordship,
If at all you want to rely upon a part of the charge sheet, which as per you is relevant, you are required to draw the attention of the IO
My lord.
and to exhibit it in the same manner.
exactly, my lord, same
It's a
man.
previous statement of
The I-
the IO.
IO.
So unless you have done that, charge sheet is not an exhibited document.
No, my lord, I understand that.
Why waste the time unnecessarily?
The allegations, what they have brought.
Forget about it. The allegations now are part of the substantive evidence.
My lord.
So only read that.
Your lordship, basic thing was that I was arrested from Bangalore. I supported, I gave shelter to Jewel Garlusa, my lord. I opened an email account and unaccounted amount of cash was there in my bank account. Now, your lordship, kindly come to the charge order. Charge order. PW 1
Volume 1.
Volume 1. My lord, I have been convicted under section 120B and section 17. So I will draw only these two sections, my lord, charges. Your lordship will kindly find at page 4 of the paper book, volume 1.
There is no particular charge against this accused of being in possession of cash,
No,
harboring.
my lord, not even that. Your lordship, let me read it. Let me read it, my lord.
We understand what you are trying to say.
First,
We got what you say.
my lord,
Neither allegation of harboring nor of having unaccounted cash in your account,
nothing.
nor of the other parties raising of funds.
Raising of funds, your lordship, raising of funds, your lord, that you after forming terrorist gang DSDJ in 2004, directly or indirectly involved raising and collecting funds or attempts to collect funds by extortion.
Fifthly, you are reading.
My lord, fifthly, yes.
Fifthly.
Fifthly, kidnapping, siphoning and deflection of government fund through Mohit Huzai and others, and in committing such activities, kidnapped R.S. Gandhi and realized 4.5 crore. Siphoning government fund with the help of R.S. Khan, Karuna Saikia, Jayanta Kumar Ghosh, Devasis Bhattacharya and Sandeep Ghosh were paying money without supply of short supply of articles, making the rate of supplied articles more than double of market rate by preparing false bill.
First read the findings against your accused.
My lord,
Then you read the charge. What are the findings of the trial court?
your lordship, my finding, the findings against me, your lordship will kindly see. Para 190. Para 190 to 198. Your lordship, the learned trial court relied upon relied upon 11 witnesses, my lord, out of 150 witnesses.
So your presence with Jewel Garlusa was one factor to decide conspiracy.
My lord.
Okay.
Second was that, if your lordship, if I read those 4 attributes were there.
Read.
He was caught at a flat in Bangalore on 3rd 6 2009, and he provided shelter to accused Jewel Garlusa, the CNC of DSDJ. Second is, he had communication with DSDJ, and email sent by accused Jewel Garlusa to NDFB organization was recovered from one email ID, dimahasao@yahoo.com to the effect. Third, he visited Aizawl and concealed his real identity of Arsindo Barisa. Fourth, 10 lakhs was deposited in his bank account at Standard Chartered Bank, Guwahati, with a short span of time, and there is no plausible explanation to show where from the money came. So these are the 4 attributes, my lord, and the finding is recorded there. Of under your lordship will kindly come to the findings. At page 423, para 423 of the impugned judgment. I'm reading it, my lord. And having considered all the material particulars, we find that the prosecution side has
There is any point-wise discussion of Harshindra Varsha, Varisha?
no, my lord.
Point-wise discussion, no.
No,
As he has dealt with the cases of other accused individually,
my lord.
there is no discussion.
No, my lord, he has gone to that discussion prior to giving me that 4 attributes.
Where,
But-
where?
My lord, it will come from 190.
Read now first, read that first.
My lord, he relied up 190. The first thing they relied upon is that evidence of PW 26
Where are the attributes you are talking about?
attributes. It comes at para 198(1).
Read that first.
He was caught at a flat of Bangalore on 3/6/2009, and he provided shelter to accused Joel Galusa, the CNC of DSG.
All right.
Now,
Males-
this attribute, my lord, the learned trial court, your lordship will kindly come at para 190.
No, we have read. Yes.
These 3 witnesses relying upon Sudhakar Singh, Rukma Buragoy, and Bhupendra Kumar Nath, my arrest part and recovery of certain laptop and mobile. My lord, no, but if your lordship will see, I will take you to the evidences. None of these 3 witnesses has said that Joel Galusa was provided shelter by me. Rather, we both went to Bangalore. And it is admitted fact in 313 that I have not disputed my arrest, my lord. But your lordship, if I will take you to the this particular 313 also.
So he was not arrested with Joel Garlosa.
No.
Joel Garlosa was arrested in a gym. And these 2 were arrested in a flat.
In the flat.
Okay.
Your lordship, in 313 also this question was put to me. Your lordship, if I because I'm not denying my arrest part, my lord. Your lordship, kindly, if I refer to 313, question number 29. My lord, 313 kon ase bana? My lord.
Read.
My lord, PW Sudhakar Singh
Yes.
also testified that on 1/6/2009, on information, he along with 2 inspectors flew to Bangalore on the order of GP Singh, where Joel Galusa, CNC of DSGJ, was apprehended in a gym, and you were apprehended in a flat along with Samir Ahmed, and both of you were brought to Guwahati on 5/6/2009. PW 38 Rukma Buragoy and PW 124 Bhupendra Kumar Nath also testified the same facts. PW 38 further testified that Joel Galusa disclosed his stay at flat 102, first floor Pankaj Residency, and led them to your flat, from where you were found staying with him. And on search of the flat, among other things, 1 driving license number so and so in the name of Debojit Singha, having his photograph was found. And from possession of you, among other things, 1 ACL laptop bearing number so and so, which is material exhibit 29. 1 driving license number so and so in the name of you. 1 identity in the name of Ananda Singha of Bihara Kachar, having his photograph material exhibit 33, and seized the same by Caesar memo exhibit 104. The search of the flat of Samir Ahmed, he found among other things 1 photocopy of driving license of Debojit Singha, exhibit 113, which is seized by Caesar memo exhibit 110. Have you got anything to say in this regard? Yes, I admit this fact, but the fact of 1 identity in the name of Ananda Singha of Bihar Kachar having his photograph of material exhibit 33 seized, the same Caesar memo exhibit 104 is false. My lord, that providing of shelter, which has been attributed to me by relying upon the evidences of those 3 witnesses who went, they were police officials, they went to apprehend Joel Galusa. Nowhere has said that I provided shelter, but from where is this particular, even in my 313, this was the only question, my lord.
Joel Garlosa gave a disclosure statement.
No.
And he led to the flat. That is.
No, Joel Galusa, there was no disclosure statement accorded from Joel Galusa, my lord.
If you read para 190, that is what the trial court says. PW 38 further testified that Joel Garlosa disclosed and led them to your flat.
My lord, as such, there was no disclosure statement. Joel Galusa, when he was apprehended,
He was taken
I
to
stay
that
in this particular flat.
No.
That's how. There's no as such disclosure statement.
Disclosure.
My lord. So what I am trying to impress, my lord, is that the attribute attributed to me, one of the intimidating attribute, yes, is that I provided shelter to Joel Galusa. That has nowhere come in the evidence, my lord.
Okay.
Now, your lordship, I will come to the Aizawl part, my lord. My niece staying in Aizawl. Your lordship will kindly see, peruse the evidence of PW 39. PW 39. PW 39, page 301.
Part 2. Volume 2. Part 1, volume 2. Yes. Three zero one. Yes.
My lord, I am the resident of village Dalurban of Korimganj district. In search of job, I went to Mizoram in the year 2000 and have been working there in the hotel. From the year 2005, I have been working in Hotel Toprikana, Jharkhand, Aizawl, Mizoram as manager, and since then I have been working in the said hotel till date. The owner of the hotel is Mohammad Ruhel Ahmed. This hotel is for food and lodging. There are about 17 rooms in the said hotel. There is a restaurant where foods are served to the guests. As a manager, my duty was to talk to the guests, provide rooms to them and other needs. Exhibit 114 is photocopy of entry register of Hotel Tropicana, Aizawl, certified by the owner of Hotel Mohammad Ruhel Ahmed. Exhibit 114-1 is entry serial number 6646 showing the name of Arsing Wari, address Shillong with father name P. Wari. In a column purpose of visit shown as transit, and in a column coming from is shown as Shillong and going to east shown as Kolkata. And the room allotted was 310, dated 28/2/2009, and checking time was shown as 3:30 p.m. This entry was filled up as required by the guest in his own handwriting. In the signature column said Arsing Wari was put his signature in my presence. Exhibit 115 is photocopy of cash book register, which is my handwriting. Exhibit 115-1 is the signature of the owner of Hotel Mohammad Ruhel Ahmed, certifying the correctness of the entry made in Exhibit 115. And Exhibit 115-2 is the entry for room number 310. Bill number so and so, and the amount shown to be shown as rupees 760 as bill for the said room. Exhibit 116 is the photocopy of daily occupancy chart.
All right.
My lord,
Assuming, yes. What do you want to make?
what I want to make is that first thing, your lordship, assuming my name is not there, Arsing the Warisa, my lord, here.
Have these handwritings been compared?
No,
No.
more. Second thing, my lord, the prosecution ought to have make me identified by this witness. If there was not,
Were you on bail on that day?
no, I was in custody.
Oh, you are in custody.
I was in custody. From the day of my arrest, I was in custody until and unless till my sentence was suspended from this court. I was in custody. Now, my lord, your lordship, since your lordship has got my crux of the argument was that only.
No identification in court.
No identification in court.
All right.
Second thing, my lord,
There's a
This-
difference in names.
this witness, which the learned trial court attributed to me, that my stay in Aizawl, hiding my identity. No incriminating question was, since there was no incriminating substance came in, no question was put to me in 3:30.
Yeah, assuming that he went to Aizawl, so what?
So what, my lord? I may go,
I mean, what is the incriminating fact in that?
nothing. But the learned trial court had drawn that conclusion without putting a question to me under 3:13.
All right, next point.
My lord.
Next.
And your lordship will kindly come to PW 56, the Aizawl part. It's just come here.
It just come.
PW 56 is done. Huh? Okay. Ravi, the case number is not 418. My lord,
Is very poor cross-examination from this. Very poor person. Yes.
Hari Singh Kamyal, my lord, your lordship, page 418. The relevant portion of connecting with Arsing the Warisa is at page 420. Again, on 6/7/2009, I was directed by CIA to visit Aizawl and verify the visit of accused A. Warisa and develop the source information regarding the suspected accused with supplying arms to DSDJ. Accordingly, I went to Aizawl, Mizoram. I collected record of Hotel Tropicana where accused A. Warisa stayed in room number so and so to so and so. Exhibit 114 is the said hotel guest register record showing the name of A. Warisa at serial number so and so. I also recorded the statement of hotel manager Sabuddin to this effect. Now, my lord, in the cross-examination, my lord, I seized whatever was made available to us in Hotel Tropicana Aizol, but ID proof of the guest was not there. It is a fact that witness Sabuddin during his statement under 161 did not tell me that Arsing Wari is actually the accused Arsing the Warisa. After so many years, I cannot identify the accused Arsing the Warisa. So, my lord, these two witnesses, evidence which the learned trial court referred, but no incriminating substance came in, my lord. But in spite of that, the learned trial court has attributed this particular fact at serial number 3 in the intimidating factor that I visited Aizol and concealed my real identity to be Arsing the Warisa. But there is no iota of evidence or whisper of evidence in chief that the Arsing the Warisa is
Same person.
same person, my lord. Now, my lord, the 10 lakhs which was deposited, my lord, 10 lakhs which was deposited in my bank account as Standard Chartered Bank. Your lordship, that for taking the fact of the deposit of 10 lakh in my bank account, your lordship, the learned trial court referred the evidence of PW 66, my lord, Nishit Barman. Page 451, my lord.
Yes.
In the month, my lord is there. In the year 2009, I was studying Bachelor of Computer Application at Central IT College near Ganesh Mandir, Guwahati. I now accused Partha Warisa, Arsindo Warisa, who is my cousin brother. In the month of February 2009, accused Partha Warisa, alias Arsindo Warisa, told me over phone that somebody will give some cash to him and he should collect the same deposit in his account. He also told me that the said person will telephone me and tell me that where he would hand over the money. The said person thereafter telephoned me and then I told him to come to my place. The said person thereafter came to my place and handed me about rupees 3 lakhs on the next day. I deposited the same amount in the account of Partha Warisa, alias Arsindo Warisa. Thereafter also about 4 to 5 days, another person came to my house and handed over rupees 3 lakhs and accordingly, I deposited the amount in the account of Partha Warisa, alias Arsindo Warisa. Thereafter also, after a week, some other person came to my house and gave me rupees 2 lakhs or more. And I deposited the same amount in the account of Partha Warisa, alias Arsindo Warisa. I also paid an amount of rupees 1,60,000 to Tata Motors as payment of loan to Partha Warisa, alias Arsindo Warisa. I further deposited an amount of 40,000 in the account of Partha Warisa at Standard Chartered Bank. In cross-examination, yes, I understand Assamese language, but I am not fluent in speaking, but I can speak Bengali, Hindi. The money which has been paid to me by those persons under instruction from my cousin brother, namely Partha Warisa, alias A. Warisa, the money belongs to stone crushing chips, which he have brought from my cousin brother, namely Partha Warisa, alias Arsindo Warisa Stone Crushing Firm. The name of the firm is Arsindo Stone Crusher. It is not a fact that I have stated on my 161 RPC statement to the IO, the following portion, which was read over to me today in this court. I was at home that day in the month of February when a call came to me on my BSNL phone. The person asked me to come below the flyover, the next ticket counter at Puri shop. Now, your lordship, this is the evidence of deposit of 10 lakhs in my account. Now, your lordship will kindly come to PW 48. At page 384.
Yes.
Soumya Kanti Roy, my lord. Since 2009, I have been working in Standard Chartered Bank, Ambari, Guwahati as customer service executive. I am still working in the same bank in the same company.
He has proved the bank statement.
Yes, no. He has proved the bank statement, but in his cross-examination, he has accepted that that
Computer generated, no.
computer, no certificate, my lord. And your lordship, what happened? Irony is that your lordship kindly come to the,
He has discarded the electronic evidence on ground of 65B not being there.
no, he discarded, when was matter was argued, that our argument was that the bank document which the prosecution.
Bankers book evidence. Act
Yes, section
certificate.
5. Your lordship will kindly come to para 193 of the impugned judgment.
And if not bankers book, at least 65.
65D. So your lordship will kindly come, para 193, third line from the bottom.
Yes.
The learned counsel for the accused has submitted during argument that the above statement is not submitted as per section 2 of the Bankers Book of Evidence Act, and thus no reliance can be placed on the same. The submission is considered in light of the facts.
Every reason to record concurrence.
Concurrence. Now, the concurrence was taken, my lord. Now, your lordship, how did the learned trial court attributed those 10 lakhs to be an intimidating factor? Kindly come to para 192(1). It is elicited in cross-examination that the money which was being paid to him by those persons under instruction from his cousin brother, namely Partho Varisa, alias Arsinda Varisa. The money belongs to stone crushing chiefs which were bought from his cousin brother, namely Partho Varisa, Arsinda Varisa, stone crushing farm. The name of the farm is Arsinda Stone Crusher. What is transpired from the evidence of this witness is that handing over the sums to him and depositing thereof in the account of the accused is admitted. Though it is elicited in the cross-examination of the witness that the money belongs to Partho Varisa, Arsinda Varisa stone crushing farm, yet the same failed to inspire confidence in as much as the amounts were handed over by different persons on different occasions within a short period whose names were not known to him. Besides, it is also not clarified where the farm is situated. If it is in Haplong, the native place of accused, then why payments have been made at Guwahati remain unanswered? How can I answer, my lord?
All right.
How do I, my lord? And moreover, my lord, this aspect, for example, if you take it as a gospel truth also, like for example, what is the question put to me in my 313, my lord?
Question regarding 10 lakhs being deposited.
No, not put.
Very good.
Huh? Now your lordship will kindly come to the disclosure part, which ties me with Joel Garlosa and for terrorist activity.
117.
Yes, my lord.
Yes.
Kindly come to exhibit 117 first. Exhibit 117. Exhibit 117, your lordship will find at volume 3 of exhibit.
Yes. Page.
Page 660. Case number 1 of 2009 under section 120B, 121, 121 IPC, 25 1B, Arms Act, 17, 18, 19 UAP Act. During the investigation of the above mentioned case, with one accused, Mr. Arsinda Varisa, my lord is there? One accused, Arsinda Varisa, made a disclosure of the fact, which read as follows. Quote, I have opened 4 email accounts. I was operating 3-4 email accounts on behalf of Joel Garlosa.
These 4 email accounts.
These 4 email accounts on behalf of Joel Garlosa. The email accounts and passwords are known to me. These email account with the passwords are, those 4 email account and the password, respective password. The disclosure memo was recorded and read over to him. Signature, my lord. The disclosure memo was prepared on 13 July 2009.
Yes.
At the SOU police station, Assam. Now, your lordship, if your lordship can recollect, that while I was arguing in Jewel's part, that when I drew the attention of this honorable court to the order of 13/9/2009. On that particular day, my lord, 13/9/2009. May I read that order, your lordship? As the disclosure was made on 13 July 2009 at the SOU Police Station, Assam. Now the corresponding, my lord, court order, your lordship will see that on 13/7/2009, the learned CGM records that accused Mohit Hosai and Samir Ahmed are produced before the court from jail hazard. Accused RS Khan and Arsinda Warisa alias Partha Warisa are not produced before the court on account of their illness. They shall be produced before the court on 27/7/2009. On that part, now your lordship kindly come to the evidence of PW 146.
Who recorded 117?
Yes, my lord.
146.
146, page 686.
Yes.
Page number 686.
Swam Prakash Pani.
Yes, my lord.
Yes.
In the instant case, I was assisting the CIO, Sri Mukesh Singh, then superintendent of police in NIA. I was also superintendent of police during that point of time, that is 2009. This was the first case of NIA, which was registered after the creation of NIA. During the investigation, I was assigned certain tasks related to investigation. I had undergone a training on computer-related documents handling at the NCRB, which cover courses on Microsoft Windows, especially Microsoft Word, Excel, and Access. I prepared a disclosure memo pertaining to accused Arsinda Warisa related to his 4 email IDs, that is Dimahasa Yao, those email IDs, my lord, with passwords. In presence of witnesses at SOU Police Station, Assam on 13/7/2009. Exhibit 117, consequently, in the said disclosure memo, Exhibit 117(3) is my signature. All these emails were attempted to be opened on 24/8/2009 in New Delhi in presence of independent witnesses, of which only one email ID, dimahasa@yahoo.com with
Yes.
dimahasa@yahoo.com with password Tomahawk could be opened, and 8 emails sent to NDFB, Harsara Jori, and Arsinda were found. During the entire process, it was entrusted that the data taken as printout from the computer was free from any viruses and malware. The printout of all these emails were taken because of the busy schedule of the NC Hills. In a busy schedule of investigating NC Hills, the undersigned was not able to carry out the recovery memo exercise, and as soon as internet access was found, the recovery memo was carried out in accordance with the provision of 65 Evidence Act. Albeit, no separate 65B certificate was prepared in the process. Exhibit 421 is the recovery memo, 421(1), 421(2), and 421(3) are my signature. Exhibit 422 in 9 pages are printout of the emails which are marked as 421. Those exhibits are my signatures and the signatures of 2 independent witnesses, namely Rakesh Kumar and Lalit Mohan Pandey.
Yes.
Your lordship, since it has been argued by other seniors also, my seniors, colleague, that with regard to disclosure part. The lordship, the witness, he says that Arsinda Warisa gave a disclosure on 13/7. What was being stated that has been not produced in the neither his signature was being, because he is the person. A punch witness can identify, but the main person who is to identify the disclosure statement is to be the person who has recorded it. He should have said that in my evidence that this is the fact what the accused says, and this is his signature, and these are the things which has been recorded. That has not been done in. Now kindly come to the cross part, my lord. Page 689.
Yes.
Fourth line from bottom, my lord.
Oh.
It is not a fact that the accused A. Warisa was not in police custody on 13 July 2009, and neither was present in the SOU police station Assam while drawing the disclosure memo, because as per the court's record dated 19/6/2009 and 13/7/2009, the accused was in judicial custody, lost in central jail. I deny the suggestion that the disclosure memo exhibit 117 and the subsequent action thereafter were all manufactured. Now, my lord, here I would like to pause for a moment, though I will take your lordship attention to that part, how the learned trial court dealt with it. For example, my lord, in my cross-examination, a particular point comes in that it is 13/7/2009. He denies it. The owner's duty ought to have been by the prosecution to pray for a re-examination on this part. On this part, pray for a re-examination at base, whether, of course, it will be subject to the findings of the trial court to clear that particular point. Or, my lord, it would have been the part correct on the part of the prosecution to refer to the CIO to clarify this aspect. But the prosecution did not do that. Rather, the defense put the query to the CIO, my lord, PW 150. Lordship, kindly come to PW 150. Your lordship will kindly come at page 785, PW 150.
Yes. What does he say?
As per the order dated 13/7/2009 by the CJM Kanur, that the accused A. Warisa alias Partha Warisa was in judicial custody. It is a fact that I have not recorded any disclosure statement of A. Warisa. Stop. Then again, my lord, I did not file any petition for taking A. Warisa from judicial custody to police custody. I also cannot say whether any of my assisting IO had done so. As far as I remember, there was a petition filed by, we stopped there only, madam. That was the 11 portions which we tried to verify from the IO. Now, my lord, how the learned trial court dealt with this particular issue, lord? Para 198.1, the impugned judgment. The learned counsel for the accused during agreement submitted that on the day of making disclosure by the accused A. Warisa, that is on 13/7/2009, he was in judicial custody. And as such, the entire exercise of preparing disclosure memo is false and fabricated. A careful perusal of the case record also shows that the accused A. Warisa was in judicial custody on 13/7/2009. But the learned special PP has contested the submission that it was error on the part of the IO, who inadvertently mentioned the date of recording disclosure memo as 13/7/2009. But in fact, the said exercise was carried out on 13/6/2009. In support of the submission, London TPS placed before the court the relevant case diary, which reflects that it was carried out, in fact, on 13/6/2009. There is no doubt that some lapses are there on the part of the IO, but it will not render the entire exercise pointless. The learned counsel for the accused has referring one case law, Mohammed Ankush versus Public Prosecutor 2010 1SC 94, submitted that the case diary cannot be used to overcome the contradictions pointed out by the defense.
Yes.
To appreciate the submission of the learned counsels, we have gone through the case law carefully and we find that the ratio laid down, the said case law is not applicable in all force to the facts of hearing the case. In the said case, the case diary was used to discard the evidence of the IO. In the instant case, no such circumstances arose. That case diary was placed by the learned special PP only to show the chronology of events mentioned therein. Moment of the 2010 system.
Yes.
If your lordship kindly come to the 2000 Mohammed Ankush judgment, 2010, 1 SCC.
Not marked. That is exhibit. That's exhibit. One, but who has proved it?
94.
Who recorded, but he has not proved. That is why this is a defective point. There should be marked X, Y, Z. Like, this creates a confusion. What is the date mentioned on exhibit 117? Is there any date? There's no date.
My lord, it is at the bottom, your lordship.
Where?
The disclosure memo was prepared on
By
13
me.
July
13 July 2009.
9.
Ah. All right. Yes, Mohammed, what do you want to read in this?
My lord, Mohammed Ankush part, my lord.
Yes.
Here the issue was that whether in a cross-examination, my lord, if a defense has succeeded to bring a particular point in favor in cross-examination, can that be diluted by the trial court by relying upon the entries or entries made in the respective case diaries?
Only. Yes. Mr. Boragoin. Maybe they got it done in the state of Pila.
My lord.
Read one PW 146 again. Page first.
In the instant case, I was assisting the CIO Sri Mukesh Singh, then Superintendent of Police NIA.
Okay, you're assisting.
Yes,
So Mukesh Singh was also there when this 117 was recorded.
my lord.
What Mukesh Singh was also present there.
No,
Okay, now read.
I was a superintendent of police during that point of time. That
Come
is,
to the part I had prepared the disclosure.
my lord. I have prepared a disclosure memo pertaining to accused Arsenal relating to his 4 email IDs. That is dimahasao@yahoo.com with password Tomahawk, Arsingda 2009, redditmail.com with password Rambo Staro, Dwara 2009 yahoo.com with password Arsing hash, and Robert Brown gmail.com with password ambassador stroke AR in presence of the witnesses at SOE police station Assam on 13/7/2009.
Yes.
Exhibit 117 consequently. In the said disclosure memo, exhibit 117(3) is my signature.
Who made the disclosure as per this witness?
As per the witness, it is me, Arsingda Barisha.
Are you sure? Does he say so?
No. My lord, he says, my lord, I had people to discuss pertaining to accuse Arsingda Barisha.
Does he prove the signature of Arsingda Barisha?
No, no, no.
You never argued.
No, I argued at the first time, my lord. I argued at the first time.
Yes. Who has marked exhibit 117/1 on the document?
My lord, this exhibit 117,
On one, within bracket 1.
that was identified by punch witness.
Okay.
Navajyoti
So-
Buragovind.
Now, the argument which is to come is that the scribe of the document, the person who records this
He
information
never exhibited.
doesn't say that this is the signature of the accused pursuant to giving the disclosure.
Yes, my lord.
That argument was not there before.
My lord, your lordship, with all due respect, you can record it and see. I made the first thing, my first was there.
You are arguing Arsingda Barisha's case today.
My lord.
Today,
But today only, today itself.
all right.
My first argument was that
Okay.
as far as the proving of 117 is concerned, disclosure with my folded hand, my lord, is that how do you prove the disclosure statement, my lord?
Yes.
Because there were a lot of arguments that have been canvassed by my other senior members at the bar, that a witness who scribe, who has or
He has to prove the contents of the document.
Exactly.
Completely.
and he has to say not only how he prove it, he has to say in witness box
The
that on
contents,
so and so
what
date.
was the disclosure?
Yes.
What
Where he
judgment
has
have you
said?
brought on that?
No.
What judgment have you brought on that
My lord,
proposition?
it's Puliakoti, this one, Pulakoti, my lord. Just,
What does it say?
my lord.
But she was there in the morning. Relevant decisions.
My lord, Pule Kotea, my lord, versus Empire.
Couldn't you find a Supreme Court judgment on the point? Read Muskim versus State of UP. Okay, all right.
My lord, what it has been said in Koteas, my lord, there are four attributes, my lord. There must be information which in consequence relate to discovery of fact. The discovery must be deposed to. At the time of receiving the information, the accused must have been in police custody. So much of the information that relate distinctive to the fact thereby discovered is admissible. Now, your lordship, if you see your lordship, this particular disclosure statement from that part, those four attributes, my lord. First, I have to be in custody. Now, as far as my custody is concerned, I was not in police custody, I was in judicial custody.
That is not very relevant actually, but still you have created a doubt that if he was in judicial custody, how did the IO get access to him?
Yes, my lord.
IO doesn't say that I visited the jail and recorded this.
No. And that's why we try to verify from the IO that did you make any application or anyone to take me on custody?
Has the accused explained where was his signature taken?
My lord, I in my 313, I have raised it very precisely, my lord. Question number 97. My lord, question number 138. Kyan Prakash Pani testified that he was assisting the CIO Mukesh Singh in the case. He prepared disclosure memo exhibit 117 pertaining to Arsing the Warisa to his 4 mail ID, which are the 4 email IDs with respective password, in presence of witnesses on 13/7/2009. And after the disclosure, all the emails were attempted to be opened on 24/8/9. One email ID, dimahasa.yahoo.com with password Tomahawk could be opened, and 8 emails sent to NDIB 2001 yahoo.com, Harsha Jore at yahoo.com, and Arsing the 2009.
What are the contents of these mails? Anyone has stated?
No.
What are the contents?
No, nothing.
Are they offensive mails? Do they indicate any
Nothing.
terrorist activity?
No, nothing.
Assuming that the emails were opened at the instance of the accused.
No, nothing has come in evidence, my lord.
All right. Okay.
Then what have you to say? The question was, what have you to say? Yes, the above fact is false. As I have never made any disclosure as reflected in exhibit 117 on 13/7/2009 to NIA in their custody. As on that day, 13/7/2009, I was in judicial custody.
All right.
Your honor may kindly see the order dated 19/6/2009 and 13/7/2009, which will prove that I was in judicial custody.
Right.
And further, I never had my email ID as reflected in the disclosure view. In view of the same, all the subsequent actions were manifested. And what best this, and not that much well-versed man can give me this reply.
He had a well-versed advocate, that we can say.
Your lordship will come. Before I go to Anku's judgment, your lordship, kindly come to PW 14 Navajit Buragoy. What he has reported. 40.
Page
40, PW. Preliminary go jago. Okay, 304.
Part 1 or part 2?
Part 1.
304 part 1 or part 2?
Part 2.
He is not getting it. Is too engrossed in the arguments.
No, it is part 1. This is part 1.
We are asking you 304 part 1 or part 2?
Oh, my lord.
Yes,
Part two.
yes, still not getting.
On 13/7/2009, my superior additional deputy commissioner Kamrup Metro Sri Minal Gogoi passed a verbal order directing me to accompany NIA officials for the purpose of investigation of NIA case 1 of 2009. Accordingly, I reported at NIA office at Game Village, Borsajari, Guwahati. From there, I, along with NIA official, proceeded to Kairipara Special Operation Unit. It was about evening hours. There, I have found quite a number of accused connected in the case.
All right,
Pen.
yes.
From the accused-
Signature was proved here.
Yes, my lord. Now, your lordship, on being, if your lordship kindly come at page 305, top portion, on being written as disclosed by Arsinda Walter, same was read over to him and he put his signature in the disclosure memo. Exhibit 117 is the said disclosure memo.
Mr. Chaudhary, how do you explain this? This is a forgery, fabrication on the face of the record. This accused was in judicial custody. How did he reach the SOU? Or you picked him from the jail? What you did?
He cannot be picked from the jail. I'll try to explain.
We give you our good wishes. How many explanations you have up your sleeve? Let us see.
And one more pertinent, my lord, here. Because normally this man, Navajit Buragoy, is at best is a punch witness to the proceeding. Now, you exhibit the disclosure statement through him. You identify the signature of mine towards him, but you don't identify that whether this was the man in chief.
In view of the fact that the man was in custody.
In the
that
man
becomes
of-
important.
My lord.
All right.
Now, what does he say in cross-examination, my lord? Page 312. I am not involved in the process of investigation of this case prior to 13/7/2009. I do not know the accused prior to 13/7/2009. I identified the accused person on the basis of the introduction as given to me by the IO. That means Mr. Pani. The accused Arsinda Varisa might not really be Arsinda Varisa as introduced to me by the IO, as I did not know him personally. It is not a fact that accused Arsinda was in judicial jail on 13/7/9 and was not in SIU police station. It is not a fact that the accused Arsinda Varisa made any disclosure statement by the exhibit.
This is an interesting answer. This is an interesting answer. Read it again. There may be a typo error. The answer is favoring the accused. It is not a fact that the accused made any disclosure by its terms.
My lord.
So the meaning is that the accused did not make any statement.
No.
Right, Mr. Chaudhary? Try to explain this also. Yes. It is not a fact that exhibit 117 is the signature of so and so.
My lord.
He denies his signature also.
So, my lord,
Kind of evidence. Yes. All right.
my lord, on the basis of these two witnesses, PW 146 and Navajit Buragoy, my lord, the learned trial court in the impugned judgment dealt with that contradiction, my lord, at para 197 of the impugned judgment, your lordship. After that, I will come to Anwar's point, my lord.
197.
Para 197 of the impugned judgment.
Yes.
Navajit Buragoy is an independent witness who remained present on 13/7/9 at Kailipara in the evening hours, as directed by Additional Commissioner Kamrup Minal Gogoi, and witnesses the disclosure made by accused Arsinda Varisa about his 4 emails and put his signature on the disclosure memo exhibit 107. The witness thus lends assurance to the version of PW 14. It should be PW 146. On the basis of PW 146, PW 40, and again, of course, my lord, the learned trial court refers to the evidence of Kumud Chandra Sharma, but Depolal Hudai was again referred for terrorist activities. So that this attribute which, my lord, the trial court has given to me at serial number 2 can be prima facie satisfied for the court. My lord, as far as judgment is concerned, my lord, 2010 1 SCC 94. Para 27, my lord, para 28.
Yes.
The section 172 of the criminal procedure has been read down, my lord. After that, a criminal court can use the case diary in the aid of any inquiry or trial, but not as an evidence. This position is made clear by section 172(2) of the code. Section 172(3) places restriction upon the use of the case diary by providing that the accused has no right to call for the case diary, but if it is for use by the police officer who made the entries for refreshing his memory, or if the court uses it for the purpose of contradicting such police officer, it will be done so in the manner provided in 161 of the code and section 145 of the evidence. Same, my lord. So, your lordship, if we see, let us take this argument in from the prosecution side only. I refer to the witness Shyam Prakash Pani that the statement which you have recorded on that particular day, he was in judicial custody. In that time, he could have said that I want to see the case diary. That is permissible, my
The
lord.
witness could have refreshed the memory,
My lord.
but the trial court, beyond the statement of the witness, could not have gone to the case diary in order to seek a corroboration of his evidence.
And when did the prosecutor give the case diary, my lord? On that day, luckily, unfortunately, there was no recording. But on that very day, when we were doing the cross-examination, where did the prosecutor place the case diary? It was not placed. And behind our backs, how it can be placed? How can the trial court ask the PP that you please give me your case diary?
And otherwise also you missed out one thing. The trial court says Nawajit Buragoin in making a statement that he was there on 13/7 has corroborated 146. So if the corroboration is of 13/7, how can he read the date 13/6?
My lord.
All right. Okay.
Of course, the lordship, that has not come from me.
We can replay the recording if you want.
No, my lord, it just come from your lordship. Sorry, my lord. My lord, the court's power to consider the case diary is not unfettered in light of the inhibitions contained in section 172 of 2. It is not open for the court to place reliance on the case diary as a piece of evidence directly or indirectly. Now, my lord, para 29 discuss was there. My lord, a reading of the said subsection makes the position clear that the discretion given to the court to use diaries is only for aiding the court to decide on a point. It is made abundantly clear in subsection 2 itself that a court is forbidden from using the entries of such diaries as evidence. What cannot be used as evidence against the accused cannot be used in any other manner against him. If the court uses the entries in a case diary for contradicting a police officer, it should be done only in the manner provided in section 145 of the Evidence Act. That is by giving the author of the statement an opportunity to explain the contradictions after his attention is called on to that point, to that part of the statement which is intended to be so used for contradiction. In other words, the power conferred on the court for perusal of the diary under section 172 of the code is not intended for explaining a contradiction, which the defense has wins to the fore through the channel permitted by law. So how the learned trial court dealt with Mohammad Ankush's case also, my lord, the law which has been laid down, my lord, is a very surprising. Okay. Now your lordship will kindly come to PW 96. (546), my lord.
Yes.
My lord, this gentleman comes on behalf of, this gentleman's name is Kumud Chandra Sharma, my lord. He comes on behalf of Mr. Kuli, late MC Kuli, who was the person who examined it?
Examined what?
Examined
Documents,
the documents, the CDRs, the case, the emails and all. And my lord, let us, he himself.
The trial court relied upon this. No.
No, but it was evidence was been read, my lord.
Maybe the trial court says that it was not proved as per law.
Law.
So it has not been relied upon by MSC.
Now, Your Lordship, kindly come to 10 PW 126 Depolal Hudai. In the year 1996, my lord, page 625.
Come to the place where he refers to your client.
My lord, he nowhere says about my name.
If at all, yes.
This witness nowhere says about me. Neither, if we take it for record, my lord, for one moment, the prosecutions, the way the prosecution declared him hostile to be correct, the procedure, my lord. Even if we refer to that part also, my lord, where he has said my name, my lord. On the basis of these four witnesses, 126 Depolal Hudai, 146 SP Pani, and 14 Navojiti Buragoy on an exhibit 117, the learned trial court comes to the fact, incriminating effect attributed to me is that I communicated with DSDJ through emails sent by accused Joel Garlusa to NDFA organization, was recovered from the email ID of the mahasa.yahoo.com. So these are the four. Now, Your Lordship, kindly come to the finding.
Para 198.
No, my lord.
Finding. Where is the finding?
These are the attributes, circumstances.
All right.
The findings, Your Lordship, is recorded. Huh? 423, 1 to 423. The Lordship will kindly come to para 423.
Yes.
It starts from para 422 only, but refers to the Sarat Division Sada's case, my lord, the punchil of that circumstantial evidence rule. Now, my lord, 423.1. The prosecution side has also been able, first, my lord, kindly come to 423. And having considered all the material particulars, we find that the prosecution side has succeeded in bringing home the charge of conspiracy under 20B against all the accused persons beyond reasonable doubt. It is to be mentioned here that accused George Lamtang has started approval and granted pardon. Accused Samir Ahmed has pleaded guilty and convicted already. The prosecution side has been able to establish beyond all reasonable doubt that the accused person, namely R.S. Khan, Karuna Saikia, Jayanta Kumar Ghosh, Devasis Bhattacharjee, alias Sandeep Ghosh, have entered into an agreement with the some members of DSDJ to do an illegal act, which is not illegal by illegal means, to help them in raising funds, and in order to commit such act, siphoned of government funds meant for development of NC Hills district and handed over the money to terrorist gang DSDJ through Mohit Hujai to procure arms and ammunition to assist in continuing terrorist act. So, my lord, the first part is that with respect to 120B is that I formed DSDJ.
As a part of DSDJ.
DSDJ, members of the DSDJ, and I collected money, siphoned the government fund.
That is not alleged to you, and you are a part of conspiracy.
My lord,
to do these things.
So now question is that the learned trial court, when they referred to those evidences, from where that evidence, this particular, any fact attributed in the findings recorded with respect to 123 has been attributed to me by any witness? None.
Okay.
Second part, Your Lordship, the prosecution side has also been able to prove beyond all reasonable doubt this accused Pojendra Hojai, Babul Kemprai, Mohit Hojai, Joel Garlusa, A. Warisa, Valna Chana, Srimati Malswa Kemi, Niranjan Hojai, after forming terrorist gang DSDJ in 2004, entered into an agreement with R.S. Khan, Karuna Saikia, Jayanta Kumar Ghosh, Devasis Bhattacharjee, and Sandeep Ghosh to do an illegally to raise fund for the terrorist gang by siphoning government funds, convert Indian currency to US dollars, to procure arms and ammunition to wage war, cause death of innocent persons, terrorize people, and extort money disrupt works of gauge conversion and construction of east-west corridor. It is, of course, true that the prosecution side had failed to establish kidnapping for ransom here in this case. Notwithstanding failing to establish this, the other parts have been proved by the prosecution side beyond any shadow of doubt, and the same unwillingly points out the guilt of the accused and accept that no other hypothesis is possible on the facts and circumstances on the record. Accordingly, the accused person named here in above are convicted under section 120B IPC. Now, your lordship, if we pause here for a moment and see, taking out other facts, here the learned trial court comes to the finding that Arsinda Varisa was a member of DSDJ with other query. So if I am a member of DSDJ, one argument, I don't know whether your lordship will appreciate or not. One argument is that if I'm a member of DSDJ, the learned trial court, as far as member of DSDJ, member of the section 20, there was no conviction accorded against me. That proves that I'm not a member of that terrorist gang or DSDJ whatsoever. So if I'm not, how can the learned trial court come under 120B, drew up a finding that I was a member of DSDJ when neither those evidence witnesses has deposed that to that effect, nor any evidence has come from inference also we can draw that I was a member of DSDJ. Next, we can start.
Yes.
Well, just to brief recount, your lordship, I started my argument with two aspects. Number one was that regarding that contradiction part, how to do it. Your lordship, I put those two authorities, three authorities in fact, all of them our own high court. And it's clearly correct how it has to be done as per the mandate of 145. Now, as far as Arsinda Varisa is concerned, my lord, I was arrested with Jewel Garlusa on 3rd July 2009.
3rd July.
3/6. 3/6 2009.
So 3rd June.
June, sorry.
Yes.
3rd June. 3rd June 2009. The NIA filed charge sheet against me. The charges were framed against me.
Do you have the details of his police custody remand?
My lord, it will be reflected from the order sheet only. Of course, it is there in the charge sheet.
What is the date of his
My lord,
police custody?
my
remand?
lord, my lord,
Just let us know.
my lord. Did the charge sheet come?
You have given that brief. Is it mentioned in that?
My lord, yes. I was arrested on 3rd/6 2009. My lord, as far as Arsinda Varisa is concerned, your lordship will kindly come to volume 1, paper book volume 1, volume 9.
Just state the date, please.
3rd/6 2009.
Oh, date of police custody remand and judicial custody. First date on which he was remanded or sent to judicial custody.
My lord. 6/6 2009.
PC was over.
No. 6/6 2009. And I prayed for taking of the Basista PS and made a prayer. Two prayers were made in that application by the IO that to transfer the Basista PS case record to NIA and all these seized articles and all. And second was that since Jewel Girl was
The prayer was allowed.
on 3rd/6.
For how many days was the police custody?
14 days, my lord.
14 days
14
from
days.
6.
13/6 2009. I will show the order, my lord.
14 days from what date?
3rd/6 2009.
All right. Okay, very well. So this is in reference to the fact the trial court referred to the case diary.
My lord.
But he was in police custody of the NIA on that day. It's a fact. But the other fact is that that witness you were referring to, Samir, what Pani, what?
Pani.
He says that he took over investigation only on 13/7.
My lord.
So he could not have been there in June.
My lord.
All right. Okay.
My lord, if we see also one thing. My lord, on 6/6/2009, just for reference, my lord, your lordship can kindly peruse the order also.
Tagging of the file, FIR
My lord,
documents.
6/6/2009, Mukesh Singh, the CIO, he makes an application before the magistrate that you please hand over the entire, you ask for the transfer of the Bosista PS case records to NIA because in compliance of the MHA, we have taken up all the seized property and articles and the FIR. Second was that since Samir Ahmed, Joel Garlosa and Arsindo Warisa were arrested in Bangalore, let their custody be given to us for scientific investigation. That is, and accordingly, my lord, the learned trial court allowed them, allowed the prayer. Now, after that, my lord, (15/6/2009), my lord, Samir Ahmed was made, we are not concerned with Samir Ahmed part, my lord. Kindly come to 19/6/2009. On custody, on completion of police custody, Mihir Gorman, Joel Garlosa, Ashna were produced before the court. On 19/6, I come back. Both of us come back.
Yes.
Now, from 19/6/2009 to my lord, 9/7/2009, till 13/7/2009, I was in judicial custody.
You stated.
So now the question is that if I have made a disclosure statement for the sake of argument also, if you and if you buy the argument of the prosecution that it should have been 13/6/2009. Now the moment when we did the cross examination, I drew the attention of the scribe, that is Mukesh Shyam Prakash Pani, that you are saying on 13/6/2000 the disclosure statement
That you argued already.
Yes, my lord. So that aspect, now with that aspect has to be cleared from the prosecution side. But when
They
you-
have referred to the case diary and the trial court relied upon that.
My lord.
Which as per you is illegal because the diary was not a part of proceedings,
My lord,
a part of the evidence.
my lord,
Yeah, he was not confronted, nor did he make any prayer
My
to
lord.
refresh his memory with it.
my lord.
All right,
And even my lord, that Ankush judgment very clear.
all right.
Now your lordship will kindly see that the learned trial court has attributed an amount of rupees 10 lakh to be in my account. And for that effect, the prosecution has examined one witness, that is Somal Kanti Roy, PW 48. My lord, though the learned trial court recorded that since Bankers Book Evidence Act is not complied, his evidence is not to be did not considered. But your lordship will kindly see the exhibit. Exhibit 214.
Volume 4.
Volume 4, my lord. Volume 5.
Yes. Page.
My lord, page will be 990.
Yes. The authorization given to the witness to appear and depose.
He appeared before the post. And your lordship, the client is also here. I just met him. I just had a brief talk also. The exhibit 214 happens to be the bank statement, my lord.
214, yes.
Bank statement. Even if we see the entire bank statement also, my lord, the amount of 10 lakh is nowhere reflected. The balance is of there is no 10 lakh.
Right. 40,000 cash. Then
October 6, my lord. Which year? It is not mentioned, my lord. October 28, 3,000 were been withdrawn. October 30, Axis Bank Limited, 3,000 deposit. Again, cash,
November, there are two deposits.
my lord. 45,000, 45,000.
90 and 1, 2, 2 and 350 and around about 4,50,000 odd.
My lord.
Hmm.
So, my lord, the attributes which has been availed against me and the findings that has been recorded. Your lordship, as far as 120B, I have already apprised this honorable court. My lord, my second argument will be with respect to section 17 of the UAP Act. Your lordship, kindly come to section 17. I was fortunate enough to hear argument of my senior, Mr. Sir. On that day, he told that as far as section 17 is concerned, my lord, even your lordship also, my lords also queried whether any Supreme Court judgment is there or not. My lord, to be very frank, there is no such judgment on 17. But on the perimeter provision of POTA, there is a judgment. I will, that is the PUCL case. My lord, kindly come to section 17. Section 17, my lord, if we read at that point of time, because there is a subsequent amendment has been done in 2013, it has been changed. But post 2008, the section 17 was a very vague. If my lord have the old act, your lordship will find the old section 17, post 2008 amendment. Punishment for raising fund for terrorist act. Whoever raises fund for the purpose of committing a terrorist act shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and shall also be liable to fine. That was the post 2008, my lord. Subsequent amendment, it has been there. But if I restrict to post
Pre-2008.
Pre-2000, sorry, pre-2008.
Yes.
Pre-2008, if we read this section, it was very vague. Whoever raises fund for the purpose of committing a terrorist act shall be punishable, my lord, for a term and with respect to fine. Now, my lord, after the 2008 amendment, your lordship will find the language and the tenor of the section has been changed. Because when the amendment was brought, your lordship, this amendment was brought in subsequent to that horrible the demonic action terrorist attack on 26/11 in Mumbai. Then the parliament decided that we have to hit at the root of the terrorism, that is financing. Now, your lordship, in that aspect, this section 17 came. My lord, if you read this section in a slowly way, whoever in India or in a foreign country directly or indirectly raises or collects funds or provide funds to any person or persons or attempts to provide funds to any person or persons, knowing that such funds are likely to be used by such person or persons to commit a terrorist act. If we pause here, my lord, here the section 17 says that whether you are in India or whether you are abroad, directly or indirectly raises, first is raise. Raising is something else, my lord. Collecting is, that is also something else. Or provides funds to any person or persons or attempts or even may attempt to provide that raise and collect and provide funds, knowing that such funds will be used for a terrorist act, notwithstanding whether it has been committed or not. So it is terror funding in general, my lord. So if we, from this section, what emerges is that though we see the word persons here, my lord, persons, I have read the old act, persons has not been defined in the UAP Act.
That can be the organization.
My lord, yes, you can take aid of the GC Act, General Clauses Act, then it will come everything. So be that if it comes in that way. My argument is that to bring a rider of section 17 with respect to any person or any individual, to bring him under the dragnet of 17. The first and foremost thing is that the substantive offense, which is terrorist act, that is defined in section 15, that has to be proved, or an inference has to be that that act is going to be committed or it was planned to be committed. Without that, and without the knowledge, you cannot bring section 17. That is my argument. Now, how do I substantiate my argument? The lordship, kindly come to section. Kindly come to section 22 of POTA.
POTA Act was.
Yes.
I read the section, my lord. Fundraising for a terrorist organization to be an offense. Subsection 1. A person commits an offense if he A. Invites another or provide money to or other property, and B. Intends that it should be used or has reasonable cause to suspect that it may be used for the purpose of terrorism. Second, a person commits an offense if he receives money or other property and intends that it should be used or has reasonable cause to suspect that it may be used for the purpose of terrorism. Third, a person commits an offense if he provides money or other property and knows or has reasonable cause to suspect that it will be used or may be used for the purpose of terrorism. Now, your lordship will see section 21, 22, subsection 1, 2, and 3. It has divided the section 17 part of UAP Act into 3, 1, 2, and 3. That is invite, that is my lord raise, then receive, and that is provide. So it has been divided into 3 parts. Further, your lordship, I am restricted to only 22, 1, 2, and 3. This particular provision, my lord, with other ancillary provisions of the POTA Act, was been challenged in the Supreme Court with us in the PUCL's case. The argument canvassed by the petitioners was that this particular section 22, there is the constituent of mens rea has been diluted. So without mens rea, anybody can be brought in. So this provision is to be struck down. Now, what the Supreme Court said was that, Honorable PUCL case today, 2004 9 SPC. Two 2004 9 SCC 580.
Yes.
Your lordship will kindly come at para 48. My lord is there?
Page
Para 48.
28.
48.
Yes.
The petitioner's apprehension regarding the absence of mens rea in these sections and the possibility of consequent misuse needs our elucidation. It is the cardinal principle of criminal jurisprudence that mens rea element is necessary to constitute a crime. It is general rule that a penal statute presupposes mens rea element. It will be excluded only if the legislature expressly postulate otherwise. It is in this context this court said in Qatar Singh's case, that was my Qatar Singh's case. Unless a statute either expressly or by necessary implication rules out mens rea, in case of the kind, the element of mens rea must be read into the provisions of this statute. Mens rea by necessary implication could be excluded from a statute only where it is absolutely clear that the implementation of the object of the statute would otherwise be defeated. Here we need to find out whether there are sufficient grounds for inferring that Parliament intended to exclude the general rule regarding mens rea element. The prominent method of understanding the legislative intention in a matter of this nature is to see whether the substantive provisions of the Act require mens rea element as a constituent ingredient for an offense. Offense under section 3(1) of POTA will be constituted only if it is done with an intent. If Parliament statute stipulates that a terrorist act itself has to be committed with a criminal intention, can it be said that the person who professes or invites, supports or arranges, manages or assist in the arranging or managing a meeting or addressing a meeting has committed the offense if it does not have intention to desire to further the activities of any terrorist organization or the commission of terrorist act. We are clear that it is not. Therefore, it is obvious that the offense under section 20 or 21 or 22 need positive inference that a person has acted with intent of furthering or encouraging terrorist activity or facilitating its commission. In other words, these sections are limited only to those activities that have the intent of encouraging or furthering or promoting or facilitating the commission of terrorist activity. If these sections are understood in this way, there cannot be any misuse. With this clarification, we uphold the constitutional validity of section 20, 21, 22. So, my lord, what I'm trying to impress upon your lordships is that section 17 of the UAP Act cannot come into operation until and unless the prosecution shows that the materials collected against me shows that prima facie there was an intention on my part for raising fund, providing fund or collecting fund for infringements of a terrorist act, notwithstanding whether it was been done or not. So in that case, intention is mens rea is to be an essential component and it has to be inferred. Now, your lordship, if my lords can recollect, of course, my lord, I believe that earlier also I have argued on this aspect. If your lordship can recollect the Nalini judgment once again, my lord, 1999 5 SCC 253.
Yes. Sir. 139. Yes.
My lord, para 650 defines, it talks about the what is terrorist act. It deals, Supreme Honorable Apex Court deals with it. The operating portion which I want ratio is that the lordship will kindly come to para 651. Even if it is repetition, my lord, I will be reading it. My lord. Mr. Altaf Ahmed, learned additional Solicitor General, has developed an ingenious argument that as the acts which are committed by the accused person have the potentiality to overweigh the government and to strike terror in the people or any section of the people, the required mens rea has to be inferred. A perusal of the charges disclosed that the intention to overweigh the government is not mentioned therein. However, Mr. Altaf Ahmed, relying upon the provisions of section 211, 212, 215, 464 and 465 of the Code, has submitted that omission to mention the ingredients of the charge did not result in misleading the accused persons and through the words to overweigh the government, but not mentioned in the charge. The charge is not bad in law. He replied on certain judgments referred, my lord, in support of his contention. In my view, the question here does not relate to the defect in the charge, but to the content of the charge. And without the said German words in the charge, it cannot be said that the charge includes the intention to overweigh the government. The charge framed is confined only to those acts which are referred to therein. This is also the view expressed by my learned brethren. Therefore, the conviction recorded by the designated court in the judgment under appeal for offences noted in category B under the TADA Act cannot be maintained. The appellants are accordingly acquitted of the charges under TADA Act. Your lordship, why I am referring to the judgment is that during my subsequent argument, I will bring why the parliament has enacted section 17, my lord, and why the parliament has enacted section 45 also, UAP Act. Your lordship will find that the German word is intent. Be it terrorist, framing of charge under the punishment for terrorist activity also 16, the intent has to be there. Now, if you read the charge order, charge it again, with respect to section 17, fifthly, my lord, fifthly, para 5, page 5.
Yes, please.
that you, after forming terrorist gang, DSG-J in 2004, directly or indirectly involved raising and collecting funds or attempts to collect funds by extortion, kidnapping, chiffoning, and deflection of government fund through Mohit Hojai and others. And in committing such activities, kidnapped R.S. Gandhi and realized 4.5 crore. Chiffoning government fund with the help of Ridaul Hussain Khan, Karuna Saika, Jayanta Kumar Ghosh, Devashish Bhattacharjee, and Sandeep Ghosh by paying money without supply or short supply of articles, making the rate of supplied articles more than double the of market rate by preparing false bill, vouchers, delivery challenge, money receipt, etc., and thereby committed an offence punishable under Section 17 of the UAP Act within my cognizance. So, Your Lordship, if you read this section, charge it again and again, the contents which is required as far as Section 17 is concerned, it is nowhere there. And if you read it also, my lord, again, it is a continuous, no full stop. I collected money, I kidnapped R.S. Khan. It was a continuance. There is no, sorry, R.S. Gandhi. I spelled out R.S. Khan, my lord. So, Your Lordship, the effect of framing charge, correct framing of charges with respect to any criminal offense has been decided in a lot of catena of judgments. There is nothing to be placing authorities. But of course, Your Lordship, I would like to draw attention of this court that when a particular person is charged for offenses under the terrorist acts, be it TADA, POTA, or UAP Act, there is an onerous duty on the part of the trial court to see whether the investigation coming up does constitute prima facie an offense applicable to Section 15 or 17, or any of the provision, because the consequence is detrimental. Because the moment you frame a charge under Chapter 4 or 6, your bail in the existence of 42D5 goes away, my lord. So why, in that context, my lord, I would like to place a judgment of the Honorable Apex Court, my lord. Hitendra's case, 1994.
Hitendra Vishnu Thakur.
My lord. The lordship is. Yes, my lord. Hitendra Vishnu Thakur. My lord, it is para 14. Para 14. My lord, it will be next page is 623, your lordship. Seventh line. An onerous duty after TADA, the lordship is fine. An onerous duty is therefore cast on the designated courts to take extra care to scrutinize the material on the record and apply their mind to the evidence and documents available with the investigating agency before charge sheeting an accused for an offense under TADA. The stringent provisions of the Act, coupled with the enhanced punishment described for the offenses under the Act, make the task of the designated court even more onerous, because the graver the offense, greater should be the care taken to see that the offense must strictly fall within the four corners of the Act before a charge is framed against an accused person. Where the designate court, without as much as even finding a prima facie case on the basis of the materials on the record, proceeds to charge sheet and accuse under any of the provisions of TADA, merely on the statement of the investigating agency, it acts merely as a post office of the agency and does more harm to meet the challenge arising out of the terrorist activities rather than deterring terrorist activities. The remedy in such cases would be to worse than the disease itself, and the charge against the state of misusing the provision of TADA would gain acceptability, which would be bad both for the criminal and the society. Therefore, it is the obligation of the investigating agency to satisfy the designated court from the material collected by it during the investigation, and not merely by the opinion formed by the investigating agency, that the activity of the terrorist falls strictly within the parameters of the provisions of TADA before seeking to charge sheet and accuse under TADA. the designated court must record its satisfaction about the existence of a prima facie case on the basis of the material on the record before it proceeds to frame a charge sheet against an accused for offences covered by TADA. Even after an accused has been charge sheeted for an offence under TADA and the prosecution leads evidence in the case, it is an obligation of the designated court to take extra care to examine the evidence with a view to find out whether the provisions of the act apply or not. The designated court is therefore expected to carefully examine the evidence and after analyzing the same, come to a firm conclusion that the evidence led by the prosecution has established that the cases of the accused fall strictly within the four corners of the act before recording a conviction against an accused under TADA. So, your lordship.
Yes.
My lords, here, if we see the finding in from this laws laid down by the apex court and the interpretation given to this panel provision, if we see the finding recorded by the Learned Trial Court with respect to terror financing under section 17 with respect to me. What is the therapy? 1, 2, 3. Kindly come to para 424, my lord, of the impugned judgment.
424.
Of the impugned judgment.
Yes.
Now coming to the charge under section 17 and 18 of the UAP, we find from the above discussion and findings that the accused R.S. Khan, Corona Saikia, J.K. Ghosh, Devasis Bhattacharya and Sandeep Ghosh have either directly or indirectly. No finding that whether it is direct or indirect, but it is supposition, directly or indirectly, conspired to raise fund for DSDJ, and we find from the evidence on the record that involved in raising and collecting funds for DSDJ, and they did so by siphoning off and deflection of government fund allocated for development of NC Hills district. And in doing so, they made payment without supply or short supply of articles, making the rate of supplied articles more than double of market rate by preparing false bill, vouchers, delivery challenge, money receipt, etc., and provide to terrorist gang DSDJ to procure arms and ammunition to assist in continuing terrorist act. The prosecution side has also been able to prove beyond all reasonable doubt that Pojendra Hujai, Babul Kamprai, Mohit Hujai, Joel Garlosa, Arsinda Varisa, Valnan Chana, Malsa Kimi, Niranjan Hujai, after forming terrorist gang DSDJ in 2004, directly or indirectly involved raising and collecting funds or attempt to collect funds by extortion, kidnapping, chiffoning, and deflection of government funds through Mohit Hujai and others, and in committing such activities, kidnapped R.S. Gandhi and realized 4.5 crore from him, chiffoning government fund with the help of R.S. Khan, Corona Saikia, Jayanta Kumar Ghosh, Devasis Bhattacharya, Sandeep Ghosh by paying money without supply or short supply of articles, making the rate of supplied articles more than double of market rate by preparing false bill, vouchers, delivery challenge, money receipt, etc. It has, of course, failed to prove kidnapping of R.S. Gandhi and realized 4.5 crore from him. It has not examined said R.S. Gandhi as witness. Notwithstanding, it has been able to establish other parts beyond all reasonable doubt. It is, however, correct that mere raising and collecting funds will not satisfy all the ingredients of the charges under 17 and 18. One more requirement, that is knowledge, is also necessary. Well, my lord, let's see how the knowledge has been inferred. But having considered all the facts and circumstances which the prosecution side has proved against them in totality, it cannot be said that all commissions or omissions have happened without their knowledge. The transaction amounts are always very high. Which transaction with respect to me? I don't have. I will go word by word, my lord. The said amounts were deflected from government fund meant for development of NCAC. Where is my fund? It was Nishit Burman who came. The same were withdrawn from utter disregard to the official norm and rules and channelized to Kolkata. Where? Under the above fact and circumstance, can it be said all this happened without their knowledge? To our considered opinion, the answer is no. It has happened with their connivance and knowledge. The government officers, A15 of PSC department and A4 of social welfare department, made payments to the contractors without supply of materials, making the rate of supply more than double the market rate by preparing false bills and vouchers, delivery challans, and money receipt. Can it be said that it happened without their knowledge? The contractors have withdrawn huge sum of money from the banks of a given day. Can it be said that it happened without their knowledge? Huge sum of money were converted to US dollar. Can it be said that it was normal business? Accused case of sophisticated arms and communication equipment were recovered instead of the accused. Can it said to be a normal circumstances? The answer to all these circumstances is emphatic no. Therefore, we are inclined to hold that the accused person have the knowledge that those funds likely to be used by such persons to purchase arms and ammunition to commit terrorist act. It is of course argued by the defense side that no knowledge could be attributed to the accused person. The submission is considered in light of the facts and circumstances on the record. But considering the materials on the record in its entirety, the submission is found to be bereft of merit. In the result, we find and hold the prosecution side has been able to establish all the basic ingredients of the charge under section 17 of the UAP Act against all the accused persons beyond all reasonable doubt, and accordingly they are convicted under the said sections of law. My lord, if pause here for a moment and you go back again to the role attributed to me, from any of those roles, is there a finding to that effect? I never had a transaction with the contractors. I never worked with government employees. I never had any iota, not a single penny has come to me. No penny has gone to me. A cash amount that 10,000 was 10 lakhs was lying in my bank account. Be it, so be it. How can it be connected with the terrorist fund, my lord?
Whether that has been confiscated or what? Is there any order to confiscate that amount?
No. My lord, if we stop at any all other things, forget about everything. If my colleague prosecution can say that this is the evidence, it links with Arsinda Varisa for raising
Give
fund.
him that opportunity. You have to take your seat.
My lord, I will. But past experience, my lord, once bitten, twice shy. That is the situation with all of our friends, my lord. Once bitten, twice shy. My lord, my last argument will be, my lord, with respect to the sanction part. Though, my lord, on 8th of May, I tried to put it, but because for various reasons, I could not place it in a much more way, a better way. I would like to place it, if your lordship.
Kumar has said much about that.
My lord, I want to, in addition to that,
Of course.
in addition to two facts I want to bring in.
Yes. Okay.
Your lordship will kindly see the sanction order ones, which what my senior colleague Kamar sir has said that non-application of mine, first argument was the non-application of mine. The 14 days time period as per the prosecution rule, 7 days for going, 7 days for coming. And in the sanction order, there is no reflection of what materials have been considered, right? And even the sanctioning authority, he said he is not a sanctioning authority. So the virtue of that is that he acted as RVS Money is a postman. Messenger boy. Now, on the basis of that, prosecution sanction has been granted, whatever. Let us say the prosecution. I want to challenge the prosecution sanction on two aspects. First is the pure non-application of mine. How I prove it, my lord? Your lordship will, if your lordship can recollect, any sanction order, be it under PC Act, be it under 196, 197, or other offenses where the sanction is required. The first and cardinal principle of the sanction order is that the person who is granting sanction must apply his mind while granting the sanction. He cannot be a mouthpiece of the authorities concerned. And how you infer that he has applied his mind? The inference can be drawn from the perusal of the bare perusal of the sanction order itself. How do we infer it? The sanction order must contain the bare minimum facts constituting the offense, which will draw that he has applied this mind and the sanction order has been granted. Now, your lordship, section 45 of the UAP Act, but I won't take much longer on this point. Sorry.
We will be thankful to you.
Pardon, my lord?
We'll be thankful to you.
My lord, I will just point it out. The bare minimum facts constituting the offense.
Yes.
I don't know where it came out. Sorry.
Emphatic arguments are being re-emphasized.
My lord. Oh, my lord. I'm so sorry.
Artificial intelligence.
My lord.
Yes.
My lord, section 45.
Yes.
Section 45, my lord. Here also I will go a bit historical perspective was there.
Yes.
Pre-2008, my lord, there was no sanctioning authority in the act UAP offences. The sanctioning authority, section 45 was inserted in 2008 amendment after that terrorist strike. Now, there were two sanctioning authorities proviso in earlier two terrorist acts. That is one Tada and Pota. In Tada, it was, your lordship, it was section 20A, capital A, where it was, I'm not referring, man, I'm just giving a brief. In Tada, my lord, no offense can be investigated or registered without the approval by the superintendent of police, by the DSP. DSP is the rank. So DSP and SP. Then Tada gone, Pota came. Pota in that Pota, case was that the state government has to accord sanction. Pota also gone, then UAP came. When this amendment provision was being made, my lord, this section 45 was being inserted. The mover of the bill, that is the Honorable Home Minister P. Chidambaram, at that point, he said that our past experiences with respect to Tada and Pota, there were gross violations, but particularly many hinterlands, political cases have been given in terrorist cases and all, because there was no filtered process to safeguard the prosecution or safeguard the accused right. So in here, as far as the UAP Act is concerned, we will give a filtering process. How do you filter it? The prosecution sanction, though it will come from the government is not the final authority. It has to come from an independent authority who will review it, and on the basis of the finding, inquiry report, the government will accord sanction or not. And that has been dealt in prosecution of sanction rules, my lord. Now, if your lordship will see subsection 2, since Kamar sir has argued extensively, I'm just putting the certain points, my lord. Here, sanction for prosecution under subsection 1 shall be given within such time as may be prescribed only after considering the report. But a report is something, not a post office thing. It's a detailed analysis.
Yes.
Now, your lordship, my lord will kindly see the list of dates. List of dates. My lord, the IPW1.
The sequence of events.
My lord,
Yes.
NIA filed the charge sheet on 17/11/2009.
Yes.
My lord. Now, if my lord will see the evidence of PW50 150.
Yes.
PW 150. Internal page is page number 775. Page number 775.
Yes.
Page number 775. Exhibit to the exhibition.
Yes.
On 11/11/2009, it will be fifth paragraph.
Yes.
On 11/11/2009, after completing the investigation, I submitted the investigation report to MHA, Government of India, for sanction of prosecution against 14 accused. Sanction was obtained on 16/11/2009, and charge sheet was filed against 14 accused on 17/11/2009. The lordship will be paused here. 11, he completes the investigation, my lord. On the same day, he sent it to the MHA. Sanction, he gets back on 16, and he files the charge sheet on 17. Now, your lordship, 11/11/2009 happens to be Wednesday, 12 happens to be Thursday, 13 happens to be Friday, 14 is second Saturday, 15 is Sunday. And if your lordship has recollect, what my learned colleague has argued, that it has to be 7 working days. And when I raised this argument, at that time I was not well versed, I mean, I was not able to put it, if my lordship recollect, that the lordship has taken that it is NIA even for them working. Well, how can they work? How can you get a sanction with the law, with the rules stipulated 7 days application of mine for this side, 7 days application of mine, total 14 days. Here you do it on 11 Wednesday, you send it, the volume of record, because you cannot send a piecemeal document, the volume of records. And MHA receives on 11, 14 you get sanction. And if you read the sanction order, my lord, which my learned colleague has already drawn upon the thing, sanction order too? Huh? Read. Exhibit 301. লিখা আছে একটা চাল পৰা নাই। My lord, exhibit 301. Attention, my lord.
Yes.
Exhibit 301, volume 6 of the exhibit document, volume 6.
Yes.
These gentlemen,
What is the page?
page number is
1321.
1321, my lord. 1321.
Yes.
Whereas in respect of crime number 170/2009 dated 1st April 2009 of Bosishta PS, Guwahati City, Assam, under section 120B, 121 and 121A of IPC and 25(1)BA Arms Act, that was registered after 2 search of 2 vehicles on 14-mile GS Road, Guwahati, and 2 pistols from accused Pojendra Hazai and ₹1 crore Indian currency from accused Babul Krampai, meant for Dima Halim Dauga, a terrorist gang active in Northeast region, was recovered. The central government, in exercising the powers conferred under section 65 NIA Act by the Ministry of Home Affairs, order number so and so, dated 1st June 2009, directed the NIA to investigate the above case. The NIA registered the above case as crime number 1 of 2009 under section so and so. Subsequently, section 17, 18, 19 of the UAP Act were added and took up investigation of the case. Whereas the central government, in terms of the provision of section 45(2) of the UAP and the Unlawful Activities Rule 2008, constituted an authority and referred the case to the authority so constituted for the purpose of making an independent review of the evidence gathered in the course of investigation. Whereas the authority has, after being satisfied on the materials available on the records and on the facts and circumstances stated therein, recommended sanction for prosecution. And whereas the NIA also moved the central government for sanction of prosecution under section 196 CRPC to prosecute offenders under section 121 and 121 AIPC. Now, therefore, the central government, in pursuance of section 45(1) and 196A and B of CRPC, after fully and carefully examining the materials before it in regard to the circumstances of the case and the recommendation of the authority as mentioned above, hereby accords sanction for prosecution under so and so against so and so person.
Yes.
Now, my lord, what I am trying to say is that if we see PW 88, my lord, sanctioning authority, PW 88.
It's 510. 510. Yes. RVS money.
My lord.
510. Volume 2, Part 1.
My lord, my lord.
Hmm.
My lord, I will be directly coming, my lord, to the cross-examination part done by my colleague R.S. Khan at page 512. In my order by the exhibit 301, I have not indicated the date on which the recommendation of the reviewing authority was received. In my order by exhibit 301, I have not mentioned in which working day the authority received the evidences from the IO. I have not produced any document before this court today regarding date of receipt of documents by the authority constituted under section 45(2) of the UAP Act. I have also not produced enclosed the recommendation of the authority along with my order by exhibit 301. In my order, I have not given any details of the material collected during investigation against this accused. And in the bottom part, my lord, I have not produced any document, or I have not mentioned any document which along with my order that NIA moved the central government for prosecution under section 196 to prosecute offences under 121 and 121A. The unlawful activities Prevention Recovery Sanction Rule 2008 is made only to describe the procedure regarding sanction under UAP Act only, and I do not know under what IPC section this rule is applicable. Now, my lord, kindly come to Jayanta Kumar Ghosh cross-examination, my lord. 8th line from the bottom, my lord. 8th line. It is correct that under section 45(1) of the provisions of UAP Act, no court shall take cognizance of any offence under UAP Act unless the provisions of under 1 and 2 are complied. It is correct that exhibit 301, I have not mentioned section 45(2) of UAP Act for granting prosecution sanction against the accused person. The witness volunteered to say that in the opinion of the Ministry of Home Affairs, section 45(1) stipulates the need for prosecution sanction, and section 45(2) lays down the procedure for grant of sanction. I did not reflect in my report the aforesaid stipulation made in section 45 of the Act. My lord, what I'm trying to impress in this cross-examination and what I want to bring it to law is that the appreciation of a sanction order and the sanctioning authority has been laid down in Privy Council's case, and Gokul Chand's case. Just a short judgment, my lord. AIR 1948 PC. AIR 1948 PC 82. My lord, what I am trying to impress is that in the judgment, the Privy Council has held that it may be desirable, my lord, that it might be desirable that the facts constituting the offence for which the sanction is required may be given. If it is not given, then
Evidence is to produce.
my lord, extra evidence is to be produced. Plus, on the record of the face of the sanction order, it must be reflected. So then application of mine can be inferred upon. Now here the witnesses say that where he has signed, he is not aware. When he received the recommendation, he is not aware. He is just a messenger boy, my lord. So that is why, your lordship, at page 324, this view is the fact is not supported by the evidence. There is no evidence to show that a report of the sub-inspector to the DM or which was not put in evidence was forwarded to the DM, nor is there any evidence as to the contents of the endorsement of the DM referred to in the sanction, which endorsement also was not put in evidence. The prosecution was in a position either to produce or to account for the absence of the report made to the DSP and the endorsement of the district magistrate referred to in the sanction, and to call any witness oral evidence to supplement the document and show what were the facts on which the sanction was given. Well, this exercise has not been done. And your lordship, last one is that 2013, 2013, 8 SCC 119.
Okay.
It definitely dealt with PC Act matter, my lord, but it referred to the overall how the sanctioning authority is to be done, my lord. It was that Mahesh G. Jain's matter.
Yes.
My lord, para 6, grant of sanction is irrefragably a sacrosanct act and is intended to provide safeguard to a public servant against frivolous and vexatious litigation. Satisfaction of the sanctioning authority is essential to validate an order granting sanction. Well, thereafter, the Honorable Apex Court discussed the judgments of various authorities. The operating portion will be para 14. My lord, is there?
Yes, yes.
For the aforesaid authorities, the following principles can be called out. Number one, it is incumbent on the prosecution to prove that the valid sanction has been granted by the sanctioning authority after being satisfied that a case for sanction has been made out. Number two, the sanction order may expressly show that the sanctioning authority has perused the material placed before it and after consideration of the circumstances has granted sanction for prosecution. The prosecution may prove by addressing the evidence that the material was placed before the sanctioning authority and its satisfaction was arrived at upon perusal of the material placed before. Which in present case, my lord, nothing has been done. The sanctioning authority, RBS money is a mere. So in view of this, my lord,
Yes.
I rest my arguments, my lord.
Okay. Very well. Yes.
Subject your lordship, I won't argue on anything else, but one thing which I would like to point out, I'm waiting what they argue on the point of 25 1D. I will just have to categorically state only 2 lines. Let them rest on 25. I will just put it. That liberty I take from this honorable.
Yes. Yes, please.
Wait, please, my lord.
Yes.
I appear, my lords, for the appellants, my lords, in item numbers 36, 37, and 44 of your lordship's vote today.
Yes.
Namely, my lords, accused numbers 12, 13, and 14, my lords.
These books you can. Yes.
Accused number 12 is Jayanta Kumar Ghosh,
Oh.
railway catering contractor, my lords.
Mm.
Accused
Yes.
number 13 is Debashish Bhattacharya.
Mm.
And A14, my lord, Sandeep Ghosh, for which even my learned friend, my lords, NNB Chaudhary will also address arguments, my lords.
Mm. Mm.
Now, my lords, your lordships have, my lords, seen the records. Your lordships have been hearing marathon arguments, my lords.
Mm.
Insofar as, my lords, the case against my clients are concerned, my lords, whom I represent, my submission, my lords, is that it's a case of no evidence, my lords.
Mm. Okay.
And I will establish it from the record that the learned trial court, my lords, with respect, has drawn inferences, my lords, including saying that the witness has not been cross-examined, or the accused has not disputed, my lords.
Yes.
And based on those inferences, my lords, certain findings have been rendered, which in my respectful submission, my lord, is contrary to criminal jurisprudence. Your lordship is well versed with that, my lord. Secondly, my lords, your lordships have also seen, my lord, how 161 statements of witnesses have been sought to be introduced, my lords, through the evidence of the investigating officer.
Yes.
Which, my lords, in my respectful submission, my lord, I don't even need to labor on that insofar as the lordship is concerned. My lord. This is not permissible.
Hmm.
The bar under 162 applies, my lords. And if that is allowed, my lords, then in that case, my lords, all that the prosecution is required is to bring in the IO, my lords, to the witness box, and he will prove the witness statements of all the witnesses, my lords, which cannot be done, and I will not labor on that insofar as lordship is concerned. Thirdly, my lords, the learned trial court in various part of the judgment, my lords, has reversed the burden of proof. Namely, that the burden of proof which is on the prosecution, my lords, your lordships knows that, my lords, that burden continues throughout. And that, my lords, cannot be reversed and put to the accused, especially in these offences, my lords, where I've been tried and I've been convicted. Then, my lords, I will also point out, my lords, that the investigation by this premier investigating agency, my lords, National Investigating Agency, has been a malified investigation. They have suppressed records, they have suppressed evidence which were in their possession, which, if disclosed, my lords, may not have required, my lords, the accused persons to go in for a trial. This has all come out, my lords, in the cross-examination. I will place that. Now, my lords, the appellants, my lords, were charged for the offences under 17, 18 of the UAPA Act, my lords, and Section 120B IPC. The judgment of the trial court, my lords, convicts the appellants, my lords, for the offence under Section 17 and the offence under 120B. Insofar as, my lords, the accused number 12 is concerned, 12 and 13, they have been given 10 years imprisonment, my lords, and fine of 25,000. Your lordships have seen, my lords, the sentence part of the judgment, my lords. It's been placed by my seniors who appeared and argued here. Now, my lords, in the charge sheet that was filed, my clients were described, my lords, as contractor and member of the HDJ. While describing, my lords, the appellants, they were described, my lords, that your lordships will find that 2213, my lords, lordships did not open it, my lords, volume 9, where the charge sheet is there, as contractor and member of the HDJ. No evidence was led, my lords, to even establish that, leave alone that I am a member of the DHDJ, that I had any connection with any member of DHDJ. There is no evidence. The remotely what they tried, my lords, was that describing Mohit Hojai as a DHDJ person, they were trying to link Mohit Hojai, my lords, with the appellants. But your lordships have already seen, my lord, there is not even a finding in the impugned judgment that Mohit Hojai is a DHDJ member. There is no finding. There is no finding, my lords, of any terrorist organization, any terrorist gang. Nobody has even deposed. One witness, your lordships knows, my lord, have seen it, said militant organization. So, my lords, my respectful submission is this, my lords, that the material on which, my lords, the appellants have been convicted, my lords, are insufficient, my lords, and does not, my lords, in my respectful submission, justify, my lords, the conviction under Section 17 of the UAPA Act. Now, my lords, please, I will take your lordship straight to the impugned judgment, my lords. That's at volume 8, your lordship's volume, my lords.
Yes. What is the para number you are referring to, please?
Yes, I will come to the paragraph. My lords. Before that, my lords.
Yes.
Please have, my lords, the points for determination, my lords, at paragraph 7, 1881, my lords, 1881. The points for determination framed. Yes. Your lordships have that, my lords?
Yes, yes.
1881 foot of the page, my lords. The points for determination are, so, my lords, 1 to 7, my lords, I am not concerned. 1 to 8, I am not concerned. My lords, please come to 9 and 9, 10, and 11.
Yes.
Your lordships will just note here, my lords, 11 and 10 are identical. They are replica points for determination, my lords. Exactly identical, 10 and 11.
Yes.
So, my lords, essentially, there are 2 points for determination insofar as, my lords, my clients are concerned. 9, my lords, at 1886, whether the accused persons, namely A4, A15, A12, A13, A14, after formation of Bima Halim Dauga, that is DHDJ in 2004, and particularly from January to March 2009, entered into an agreement with the members of DHDJ to do illegal act or an act which is not illegal by illegal means, to help them to raise their funds, and in order to commit said illegal acts, siphoned of government money allotted for development of NC Hills directly, district handed over the money to the terrorist gang through Mohit Hojai in raising the fund, convert Indian currency to US dollars to procure arms and ammunition to assist in the continuing acts. Now, insofar as agreement with any member of DHDJ is concerned, there is absolutely no evidence. There is absolutely no evidence that any money was handed over to any terrorist gang member. And the last part, that on conversion of Indian currency to US dollar, that's not even the case of the prosecution, that these appellants were involved in conversion of the currency into US dollar, or that money when going from them has not been proved to have been converted into US dollars. Now, number 10, whether the accused persons, namely, after the formation of Dima Hasao, Dauga, so and particularly from January to March 2009, conspires, attempts to commit, or abets, advises, incites, directs the terrorist gang for commission of terrorist act, or did preparatory acts such as raising of fund, conversion of Indian currency to US dollars, to procure arms to the commission of such terrorist act. This was in fact a part of the charge under section 18. I am not been convicted under 18. I'm been convicted and sentenced under 17.
17 only. Yes.
17 and 120B. Now, before I come to the findings, just permit me to read page 1899, paragraph 14 and 15, where the conspiracy took place and what is the case of the NIA against the appellants. Your Lordship says 1899, paragraph 14, where the conspiracy took place. It has been submitted by learned SPT that the conspiracy took place at Haflong, the district headquarters of Dima Hasao, the erstwhile not at Kachar Hills. It is further submitted that to further the main conspiracy part, conspiracies took place at different places. One such part of conspiracy that took place at Haflong comprising of overthrowing the elected regime of NCHA led by Depalal Hoda and defalcation of government fund meant for development of NCHA and commit terrorist act to terrorize the people and wage war against the government. This part of the conspiracy, overthrowing the government and all, there is no evidence. The Lordships have seen that, but in any event, the appellants, falls in the second part of the conspiracy, The second part of the conspiracy as submitted by the special PP took place at Guwahati in the month of March 2009, where a meeting was held at Hotel Pragati Manor. This is a hotel in Guwahati, between Mohit Hojai, who became the chief executive member of North Kachar Hills Autonomous Council after overthrowing the elected regime of Depalal Hojai, and the government officers and contractors. It is further submitted that in the said meeting, decision has been taken to issue advance checks, and accordingly checks were issued in advance without any work order and execution of work. The checks were encashed and huge amount of sums were withdrawn. And the third part of the conspiracy, it says the third part of the conspiracy, according to the SPP, took place at Kolkata. It is alleged that as part conspiracy, the siphoned out money was sent to Kolkata by various means, including Hundi operator, to convert the same into dollars so as to purchase arms and ammunition. No material insofar as the third part is concerned. Essentially, I have to make good the second part of the conspiracy, the involvement, if made out in the second part of the conspiracy.
Yes.
So, before I take the Lordship to the evidence and the exhibits, first, let me just take your Lordship straight away to the circumstances highlighted by the trial judge against the appellants. This the Lordship will find at para 379, page 2111. Your Lordship says it?
Yes.
Para 379. From the evidence discussed above, the role so played by the three accused persons are recapitulated as under. Number one, he used to, this is Jayanta Kumar Ghosh, he used to do contract works in the name of the 5 firms registered in the name of Debasis Bhattacharya, Ma Trading, Loknath Trading, Jit Enterprise, Borel Enterprise, Debasis Bhattacharya, permits of which were valid up to 31/3/2008. Now, matlab, there is no evidence, though few witnesses have said these firms belongs to the appellant in the second matter, Debasis Bhattacharya. These firms are proprietorship concerns. And this is also an incorrect finding that the permits were valid till 31/3/08. I will point out from the evidence itself that the permits were all valid and these firms were existing functioning firms. Number 2, he has nexus with accused Mohit Hojai, who was CEM of NCHSAC at the relevant time. So, but that's how they are trying to rope me in, saying that I had nexus with Mohit Hojai, who was then the chief executive member of the district council. He remained present at Hotel Pragati Manor in the month of March 2009, where accused Mohit Hojai and the executive engineer PHE Haflong, KB Mukherjee this gentleman KB Mukherjee is PW 94 The evidence will be important. I will place that in a while.
Yes.
And executive engineer of Maibong division, Sri Kutan Namasudra. Your Lordship will just note here, Namasudra was not examined, he was dropped as a witness.
Yes.
Also remained present, and at that time, CEM Mohit Hojai directed executive engineers to issue all the checks in favor of Ma Trading, a firm of accused Jayanta Kumar Ghosh, registered in the name of accused Debasis Bhattacharya. 4, having regard to the checks, he got 2 accounts opened at State Bank of India Zoo Road branch in the name of the 2 firms, proprietors of which were Mr. Debasis Bhattacharya, and on 27/3/09, and deposited a high value check of 1.3 crores and withdrawn a huge amount of 84,000 after 2 days. I just pause here for a moment, my lords. The NIA, my lords, at the stage of investigation and in the charge sheet, was trying to link this money, my lords, to the money which was confiscated, which was seized from Fojendra Hojai on 1/4/09. But, my lords, in fact, at the NIA's instance only, my lords, an application was filed before the trial judge, and the seized money was opened. When the monies were opened, it was opened, looked into, my lords, no money from Zoo Road branch was there. That's the observation memo, my lords. I will place that also. Number 5, he had nexus with accused Mohit Hojai, and Mohit Hojai told PW 21 C. Chandra Sharma to meet accused Jayanta Ghosh and sent 1 man with a packet. And having received the same, he handed it over to him, Jayanta Kumar Ghosh. So some packet was given, my lords, the envelope was given. That's also, my lords, a circumstance taken against the accused. Then 6, he had nexus with Imdad Ali. Your lordships will mark that, my lords, I will place his evidence. He is PW 35. He is not an accused. He had nexus with Imdad Ali, who carried money of accused Mohit Hojai on several occasions to Kolkata. But this Imdad Ali is not an accused. He is a PW, my lords, I will place his evidence. Then once, while PW 34, Mr. Debasis Bhattacharya, it's not Bhattacharya, no, he's Debasis Datta, was returning from Kolkata by train, he was handed over a sealed envelope by D. Ghosh, D. Bhattacharya and Sandeep Ghosh, to hand it over to one of their common friend, Imdad Ali. Imdad Ali, my lords, I just pointed out, is PW 35. Accordingly, he handed it over to Mr. Ali. Later on, he came to know, my lords, the envelope was containing a check amounting to 1.20 crores. All hearsay, my lord. He said, later on, I came to know that the envelope contained 1.20 crores.
Yes.
Then 8, my lords, he has nexus with accused RH Khan, A4, and some challans and bills of supplying materials in the name of the firm Debasis Bhattacharya were recovered in the hard disk, which were seized from the official computer of RH Khan. But this also, my lords, I'll point out from the evidence, my lords, that nothing of this is proved. Now, 9, my lords, no satisfactory explanation has been offered as to how the bills and challans of the firm which he was doing contract finds place in the hard disk of the computer of accused RH Khan. This has, my lords, already come in evidence of 2 witnesses, my lords, who has in fact said that these challans were all forged and fabricated. But, my lords, saying that I didn't give any explanation, so that's a circumstance against me. Then 10, there were excessive supply of material after arrest of accused Fojendra Hojai on 1409. And prior to that, there was no supply of material as evident from the evidence of PW 103 Sushil Chandra Das. But these are GI pipes supply orders which were given to me, and I supplied. Now, PW 103 Sushil Chandra Das was compelled to show receipt of material at back date and to verify the bills of Messrs. Loknath Trading and Messrs. Jeet Enterprise. Material were started to send in April 2009. Then, payment to the firms from where materials were purchased were made in the months of April, as is evident from PW 17. This, again, is contrary to the evidence. I will place the evidence, of the witnesses. Then 13, admittedly, the accused did not participate in tender process as bidder, notwithstanding. Messrs. Jeet, Messrs. Loknath, Messrs. Ma Trading received supply orders of GI pipe for a huge sum, para number 105 of written argument. This is extracts from the written argument of NIA. Then blank challans of Ma Trading without challan number and date, wherein storekeeper has put his signature on the printed words, received the above, which is in good conditions, are supplied by J.K. Ghosh, shows existence of nexus between R.H. Khan and clearing of Exhibit 7043 Bill of Ma Trading and 70/50 Bill of Boroil Enterprise, which are without date, were cleared by R.H. Khan, further fortified the unholy nexus. Then Exhibit 279 shows that the firms Boroil Loknath had no existence in Guwahati and also had no entry in the Guwahati Municipal Corporation Register for the year 2009. This is a perverse finding, contrary to the material on record. Then 16, accused Mohit Hojai exerted extreme pressure to the officers of PHC department to issue checks Exhibit 318 and Exhibit 319, even without supply of any material. And then 17, your lordships will note, is similar to circumstance number 7. So it's a repetition. Now, similar circumstances against Devasis Bhattacharya, at page 2113, he had 5 firms registered in his name. These are the firms, permits of which were valid up to 31/3/08, and through the said firms, accused Jayanta Ghosh used to contract works with NCHC. He remained present at Hotel Pragati Manor in the month of March 2009, where accused Mohit Hojai and executive engineer PHE, Haflong KB Mukherjee and executive engineer of Maibong division, Namasudra, also remained present. And at that time, CEM Mohit Hojai directed executive engineer to issue all the checks in favor of Ma Trading, a firm of accused Jayanta Kumar Ghosh registered in his name. There is no evidence, that his presence was there in Pragati Manor. Number 3, having received the checks, he got 2 accounts opened at SBI Zoo Road branch in the name of Ma Trading and deposited a high value check of rupees 1.3 crore and withdrawn a huge sum of 84,000 after 2 days. His associate Jayanta Kumar Ghosh is known to accuse Mohit Hojai and witnesses Imdad Ali. And Mohit Hojai sent money in different occasions to his associate Jayanta Ghosh, sometimes through Imdad Ali, sometimes through Hundi operator. Once while PW 34, this is the same repetition of the circumstance against Ghosh, was returning from Kolkata by train, he was handed over. I'm not reading this, Then 6, he has nexus with accused R.S. Khan and some challans and bills of supplying material in the name of the firm were recovered in the hard disk which were seized from the official computer of R.S. Khan. No satisfactory explanation has been offered how the bills and challans of the firm under which he is doing contract finds place in the hard disk of the computer of accused R.S. Khan. There were excessive supply of material after arrest of so-and-so. PW 103, this is again a repetition of what is there for Jayanta Kumar Ghosh. And 10, payment to the firms from where the materials were purchased were made in the months of April as evident from PW 7. Then again, without participating in tender process as bidder, Messrs. Jeet Enterprise, Loknath, Ma Trading received supply orders of GI pipes for a huge sum. Then blank challans of Ma Trading without challan number and date, wherein storekeeper has put his signature on the printed was received. The above, which is in good condition, is supplied by J.K. Ghosh, shows existence of nexus between him and R.H. Khan. And clearing exhibit so-and-so. Exhibit 279 shows that the firms Boroil and Loknath Trading had no existence at Guwahati and also had no entry in the Guwahati Municipal Corporation. Accused Mohit Hojai exerted extreme pressure to the officers of PHC department.
These are all repetitions.
The same against Sandeep Ghosh. Lordships will just note, Sandeep Ghosh has been convicted, my lords, on the basis of mere association, that he is close to Jayanta Kumar Ghosh, he is close to Devasis Bhattacharya. Against him, my lords, if there is no evidence against Ghosh, there is absolutely no evidence against Sandeep Ghosh.
All right.
Now, my lords, your lordships have seen in these findings, there is no finding that money that I was in any manner, my lords, funding any terrorist act, or that money from my account or anywhere went to the terrorist organization,
All right.
much less to the DHDJ. There is there's not even a circumstance alleged against me in which what has been called out that I directly or indirectly raised or provided funds, my lords, to a terrorist organization or to a terrorist gang. In my respectful submission, my lords, these circumstances which have been called out, my lords, by the learned trial judge, assuming even I accept the same, my lords, supposing we go on a demurrer that yes, we accept everything. Even then, my lords, the offense under 17 is not made out. That's my respectful submission. Absolutely no. There is no material, not even a suggestion, not even, my lords, even a whisper that I was funding, my lords, terrorist activities, or that money was going from these three accused persons into, my lords, the hands of the terrorists. Because any lordships knows, my lords, section 17, my lords, I will not read out. But section 17 is very clear, my lords. It says, my lords, knowing that such funds are likely to be used in full or in part by such person, or by a terrorist organization, or by a terrorist gang, or by an individual terrorist to commit a terrorist act. So, my lords, knowledge is essential. I have to have definite knowledge that money I am funding is eventually going, my lords, for a terrorist act or to a terrorist organization or to a terrorist gang.
All right.
So yes. Not even one circumstance, my lords, even remotely suggests that money from me went to the terrorist group or a terrorist gang or a terrorist organization, my lords. So my respectful submission is, my lords, there is no material at all to even draw an inference for the offense under section 17 UAPA. Now, my lords, please come straight away, my lords, to the consideration of the case and the evidence against me at 2075 paragraph 304.
Yes.
Before that, my lords, just permit me, my lords, to place paragraph 127, my lords, at page 1942. Insofar as Mohit Hoja is concerned, my lords. If, my lords, I am been prosecuted, I have been convicted, my lords, in my alleged, the prosecution was that I was close to Mohit Hojai. Mohit Hojai was the man, the front of the HDJ. So, my lords, there is, NIA has let no evidence to show that Mohit Hojai was a member of the HDJ. And if Mohit Hojai is out, my lords, I cannot, my lords, be even said that no, just because you were in connection with Mohit Hojai, you had definite information that ultimately the money which was going, though there is no evidence of any flow of money, was for any terrorist act. Now, the Mohit Hojai's consideration, my lords, starts at para 63. I will just take your lordships to para 127, my lords. On a dispassionate analysis, your lordships has the second sentence of the above evidence, the facts and circumstances appearing against accused can be recapitulated as under. He has written a letter to the superintendent engineer NC Hills, Haflong, to award a contract to Kojendra Hojai. That's not. And two, he has connection with Karuna Saikia A50. He's the deceased accused, my lord. Yes, ma'am. He called Kalyan Brata Mukherjee. This is KD Mukherjee, PW 94, my lord, executive engineer PHE Haflong, to Hotel Pragati Manor in the month of 2009 and forced him to issue checks to some firms registered in the name of Devasis Bhattacharya without supply of any material. 4, he compelled Nikhil Kantanath to verify bills of March trading for payment without receiving any material. Despite weak position of PLF fund and despite recommendation of the principal secretary NCA, he approved withdrawal of amounts more than recommended. Then 6, immediately after resignation of Depolal Hojai, he became CEM of North Kachar Hills. And the resignation of Depolal Hojai is a consequence of conspiracy heads by him with other accused. Your lordships have seen, my lord, there is no evidence. Rather, the evidence is he resigned because of ill health.
Yes.
Now, my lord, George Lamtang, who was instrumental in converting money to US dollars, possessed one mobile number, and the subscriber ID of the same was as Mohit Hojai, and the service provider was Airtel, not proved, my lord. He sent money to Kolkata meant for Jayanta Kumar Ghosh through witness Imdad Ali. And 9, he sent money to Kolkata on several occasions to Hundi operators, namely Shyamji. He was in touch with accused Pojendra Hojai, where he was carrying the sum of rupees 1 crore. And then one note dated 3rd November 2008 in his name addressed to Principal Secretary NC Hills Autonomous Council, requesting him to issue supply order of different materials, sewing machines, etc. as per the approved rate of Autonomous Council Hafnam for the year 2008-9 to the list of suppliers from enclosed therewith, which also contains the name of firms of accused Debasis Bhattacharya, were recovered in the material object number 78 in a hard disk bearing so-and-so. In material object number 79 is another hard disk bearing so-and-so, which were seized from the official computer of accused Arez Khan, thereby establishing his nexus with accused Arez Khan and accused Jayanta Kumar Ghosh, Debasis Bhattacharya and Sandeep Ghosh. But I fail to understand, my lord. The allegation here is against, my lord, the firms of Debasis Bhattacharya. But the inference at the end is he roped in, my lord, accused Jayanta Ghosh and Sandeep Ghosh also. But, my lord, what I was trying to impress your lordship says there is absolutely no, not even a circumstance alleged against Mr. Mohit Hojai, that he is a member of DHDJ, either active or passive. Not even a whisper that he was in any manner a sympathizer of this DHDJ. Now, my lord, I take your lordships now back to 2075 paragraph 304. The lordship has paragraph 304.
Yes.
The learned special PPNI has submitted that these 3 accused involved in siphoning of funds of 2 government departments, PHC department and of social welfare department, and facilitated funding of DHDJ. It is further submitted that all the 3 accused acted together and played a key role in the conspiracy. It is also submitted that the firms in the name of which they were doing contracts works were registered in the name of Debasis Bhattacharya, permits of which were valid till March 2008 only. They never participated in the tender process, and yet they got the supply orders in the name of the said firms, and they submitted the bills without doing supply works and received the amount. It is further submitted that the materials against them are clear and cogent enough to prove the charges against them. So your lordships will skip that and come to 307 paragraph. PW 128.
Yes.
PW 128, Mukut Kemprai was the principal secretary of North Kachar Hills Autonomous Council at the relevant time. His evidence has been discussed already in previous paragraphs in respect of other accused persons. But from the standpoint of the present set of accused, the same bears immense importance, and therefore the same is reiterated again. According to this witness, he gave reply to some queries of NIA about some firms. These are the 5 firms of Debasis Bhattacharya, my lords, wherein he stated that permits were issued in the said firms on 31/108 under serial number 384 to 381 in favor of Debasis Bhattacharya, son of so-and-so. The registration of the same was in the department and there was no contact number. All permits were valid up to 31/3/08 and not further renewed. Exhibit 394 is the said letter. Exhibit 394-1 is his signature. The registration of the contractors were done in the PWD department, and his office used to send only permits, and hence registration number is not available. Cross-examination of this witness by the accused, Debasis Bhattacharya, reveals that all the firms were genuine and registered as per the rules of NC Hills Autonomous Council. So, my lords, in the cross, this witness admitted that the firms are genuine, they are functioning firms, they are existing firms, and this fact has also been admitted, my lords, by the investigating officer Mukesh Singh. During his cross-examination, he said, yes, I had verified these records are genuine, authentic records, which shows that these firms are indeed existing. Yet, my lords, your lordship saw, my lords, that one of the circumstances which has been culled out is that these firms were invalid, and because their validity expired on 31/3/2008. Now, my lords, PW 74 Heman Das is the sub-inspector of special task force so and so. His evidence revealed that he made inquiry and verified the addresses of Messrs. Borel, Messrs. Loknath, and made inquiry but could not find existence of the said firms of said two firms on 8809. He submitted his report on Exhibit 279 in the said report. His signature is so and so. He was present as witness in the inspection of GI file received from JIT Enterprise at Umrangso. An inspection memo and a report was prepared, and so is the inspection memo. Nothing tangible could be elicited in cross-examination of this witness to discredit his version. Now, let's please, at this juncture, let me just place the evidence of Hemant Das. This is page 470, volume 2.
This is.
I've been noticing your lordships have been immensely patient, my lords. 470, my lords.
Yes, please.
Hemant Das. He claims, my lord, he made an inquiry about the existence of these two firms in Guwahati. And he found, my lord, that these firms were not existing. Just in 2009, I was working as sub-inspector of police in special task force. I was attached to the NIA in the same capacity. In the year 2009, K.S. Thakur directed me to verify the address of Borel at Ulubari, Guwahati, and Loknath Trading at Paltan Bazar. Accordingly, I made local inquiry by visiting the area and asked the local people of the area of the existence of the two firms. I also visited Guwahati Municipal Office at East Sarania. I pause here for a moment. Your lordships have also seen the evidence, my lords, how, my lords, the postmaster sent letters, my lords, to verify the addresses of these firms. Well, I could not find the existence of the above two firms, and there was no entry in the Guwahati Municipal Corporation registers. Accordingly, I submitted my verification on 8809. Exhibit 279, under objection, is the said report, and Exhibit 279-1 is my signature. On 23/8/09, I was witness to the inspection memo. This is lordships will speak. Please see the cross-examination. As I must tell you, lordships, my lord, that we have the benefit of an extensive cross-examination, my lord.
Right.
Insofar as these accused persons are concerned, my lord, that time Bhaskar Raj Pradhan, senior advocate, he is now a judge in Sikkim, my lord.
Okay.
He conducted the trial on behalf of my clients.
All right.
Cross-examination for accused Jayanta Ghosh. It is correct that in the year 2009, I have joined as Sub-Inspector of Police NIA from STF. It is correct that Sub-Inspector of Police NIA, I investigated the matter. It is correct that today I have not shown any document before the court that Mr. K.S. Thakur has authorized me to investigate in respect of verification of addresses of these firms. So and so. It is correct that K.S. Thakur has not given any written order in respect of verification of the addresses of Borel and Loknath. It is correct I did not mention the date. I verified in the office of Guwahati Municipal Corporation. It is correct that I have not mentioned the name of any officer of the GMC who verified the record. It is correct that exactly I cannot see the territorial area of Ulubari and Paltan Bazar. It is correct I have not taken the record of register book of Guwahati Municipal Corporation from the office of East Sarania and Pan Bazar. It is correct that I have not taken any statement from the official of Guwahati Municipal Corporation in respect of verification of funds on Messrs. Borel and Messrs. Luke. Completely perfunctory inquiry, Millers. It is correct that I did not mention the name of a person who asked by me about the address of the two factories as mentioned above. It is not a fact that I did not go for any spot verification in regard to the existence of the two factories. It is not a fact that I did not go to the office of GMC to verify the records. It is not a fact that I verified the records as per instruction of DSP and I. It is correct I verified the records, address of Loknath and not Messrs. Loknath Trading. Please mark that, Millers. He verifies the address of one Loknath Enterprise, not Loknath Trading. It is correct that in my report, the word enterprise was struck down and written down the word trading without my knowledge. I will place this document. I do not know who has struck down the word enterprise and put the word trading. It is not a fact that merely on inference, I submitted the aforesaid report dated 8809. It is not a fact that I have submitted report on 8809 as it was a holiday and second Saturday. I take your losses back to 309 minutes, paragraph. The evidence of Sri Haripada Burman is also discussed in the previous paragraph. What is transpired from the evidence of this witness that Ma Trading, Jit Enterprise, Haflong, so and so Debasis Bhattacharya were found to be not traceable. By his letter, he informed NIA about the same, that Exhibit 122 to 30 are registered letters sent by NIA in the name of different firms and persons located by the postman. I'm sorry, Malaz, this is Hemen Das. So, this Haripada Burman, PW 41,
Yes.
is the postmaster, Malaz, who issues a few letters in the name of the firms. And those letters, your lordships will find, Malaz, Exhibit 120 at 663, Volume 3.
Yes.
Of the exhibit volume, Malaz.
$663, yes.
Malaz, has that, Malaz?
Yes, can you?
This is, Malaz, a letter from Bularam Terang, Malaz. He is the Inspector of Police, Malaz, attached to NIA. He wrote, Malaz, to this particular gentleman and says, in connection with the above related case, it is urgently required that the following mentioned names and addresses whether existed at the Haflong town area or not. Malaz, please see, Malaz. He has been asked to verify whether in Haflong town area these firms in existence. Your lordships will just record, my lord, these firms are located in Lower Haflong, not in Haflong town. Now, your lordships will see number 5, Messrs. Debojit Bhattacharya. There is no Debojit Bhattacharya. He is Debashis Bhattacharya. And based on this letter, my lords, please first have 664. 664 is the same, my lords, the typed copy. And
this is the reply by the postmaster.
Postmaster.
This is the reply by the postmaster.
Postmaster. Yes, I'm grateful. He says, with reference to a letter number nil, the undersigned instructed the delivery staff to trace out the addresses of the firm mentioned by you. But with great regret, I would like to inform you that the delivery staff of this office were not able to trace out the addresses. And again here, my lords, number 5 is Debojit Bhattacharya, Haflong.
You are referring to this Lower Haflong. Whether
Yes.
this question has been put to this witness.
Yes, yes. He has been extensively cross-examined. Straight away, my lords. Please come to page 314, volume 2. Volume 2, my lords. 314.
Yes. Yes. 314.
Yes,
Yes.
So here, my lords, he talks about first he says, my lord, what report he
No.
gave.
What we are asking you.
Yes, my lord, please.
Did you put any question to the police inspector who gave this requisition to the postmaster that you have given the details even of Haflong and not of Lower Haflong?
This was put
What
to the
is-
investigate. This officer was not examined. Terran was not examined, my lords.
He was not examined.
Not examined. Terran was dropped.
And where do we get it from that the firms were functional in the Lower Haflong? Where do we get that from?
Well, please come to 324 minutes, our part of the cross-examination.
324.
Yeah, before that, will your lordships also have 317 minutes? 317 minutes. Haflong is a big area. I do not know how many square kilometers. I am the postmaster of Mukhia Dagghar. That is the GPO, my lords.
GPO, right.
Yes, sir. There are 16 number of branch post offices at Haflong, and these post offices are so and so. Now let's turn about the page, minutes. Come to 319.
Yes.
Please see the perfunctory nature of the inquiry. On 13th of August 2009, 319 minutes at the top. I was called by the officer of NIA, and accordingly in the evening time, I went to NIA camp at Circuit House, Haflong. Then this letter white exhibit 120 was handed over to me by the NIA officer. On the next day, I submitted the report. Exhibit 120, the address of the addressee firms are incomplete addresses. Just mark that, minutes. The address of the address, these forms are incomplete addresses. When our office receives the letter from any other officer or any other person, then that letter must be recorded in our receipt register. I do not remember whether Exhibit 120 was recorded in our receipt register of our office, and I have also not brought the receipt register. Then next para, I have not brought any document regarding the instruction given to any delivery staff to trace out the forms after receipt of the letter dated Exhibit 120. I have not done any inquiry personally from my side, but I have given the instruction to the delivery staff.
Mr. Chaudhary, what we are trying to find out is that you have tried to highlight that the firms were actually functional in lower Haflong.
No, that 324 minutes, where the cross-examination of my 324, cross-examination of my client minutes.
But this man would not be knowing it, no? He
No,
was
this man
just
was
given an inform-
No, this man was us because he's the postmaster of the GPO.
Understand, but the firms were actually functional under the lower Haflong post office. This fact you will have to prove from the official addresses of the firms. Where do
Yes,
we
ma'am.
get that? This is a suggestive question
Yes,
or
ma'am.
suggestive argument that actually the firms could not be located because the wrong post office was chosen.
Yes, madam.
So where do we get that? What was the actual address of the firms? It was lower Haflong and it was not Haflong as such.
Just give me a moment, minutes. These are only suggestions put to the witness, my lords.
Right. So the suggestions are given. He has answered that I have done it within my jurisdiction, that is Haflong, which does not cover the Haflong police station, that Haflong police
Police training center.
and the lower Haflong.
Lower Haflong.
But what is the significance of this suggestion? Is it your case that your firms are functional in the lower Haflong area?
Yes, my lord.
So how do you
That-
establish that, sir?
1 second, my lord. That was put my lord, to the investigating officer. Just give me a moment, my lord.
Your associate is trying to assist. Yes.
In volume 7, exhibit volume,
Hmm.
page 1513.
Yes. What are you trying to tell us? Let us know. Yes.
Exhibit my lord 1513, my lord.
Hmm.
In this category, it is stated that with reference to letter number, I am furnishing the information required by marketing, note marketing, details by Borai. All the above contract supply were issued to sales developer deposit, society, lower Haflong and seal.
Hmm.
This is the address.
Your bill book does not disclose this. The bill book simply says Mart Trading, so and so contractor, so and so. Hmm.
Here the address is
You're reading at page number.
1513, my lord.
You see 1497. Read 14. The factory is at Bishnupur. Page 1517.
1513, my lord.
1513.
Permit has been issued in that name, my lord.
Hmm.
Depas is Society, lower Haflong and seals.
All right.
On the basis of that address.
But where were the firms registered, or what was their official business
Yes,
address?
yes, but that is the address.
That is the address.
Yes.
All right. Okay.
I'm grateful, my lord, friend.
Yes. All right. Okay. Yes, please carry on.
Yes, my lord. So, my lord, this inquiry, my lord, which was conducted through PW 41, your lordship had seen was a perfunctory inquiry, my lord.
All right. Yes.
The addresses given were incomplete.
Hmm.
It was not even within his jurisdiction.
Hmm.
And this witness himself admits that within a day, my lord, he gave the report.
Hmm.
So that's, my lord, the material which is placed to say that these firms were non-existent firms, they were fictitious firms in the way, my lord, that they were not existing on the day. Now let's may take your lordship back to the impugned judgment, my lord, that para 3091.
Yes.
It is elicited in cross-examination that in some of the letters, PIN number is not available, and in some letters, the name of the addresses are wrongly spelled. It is further elicited he is not acquainted with the initials put up by the postman on the letters, but in re-examination by the defense side, he stated that even if postal index number is not mentioned in letters received by the postal officers in normal course of receiving letters, but still the delivery of such letters is possible. Then 3092, my lord, it appears that out of the 30 letters, Exhibit 12216 was sent to Debashish Bhattacharya, was sent, so-and-so exhibit was sent to Loknath, so-and-so exhibit was sent to Ma Trading, so-and-so was sent to Borel, and so-and-so was sent to JK Traders Haflong. But none of them could be traced out in the said addresses. This shows, please see the inference normal. This shows that the said firms of Debashish Bhattacharya are not in existence in the addresses.
Yes.
It is to be mentioned that the firms have supplied material to Social Welfare Department and also to PhD Department. My respectful submission is, my lords, that this inference, abrupt inference drawn, my lord, is contrary to the evidence. The evidence does not justify, my lord, such an inference to be drawn, my lord, by the trial judge. And to say, my lords, that this was a non-existent, that these firms were not existing in the addresses is, my lords, a perverse, incorrect finding, my lords.
Okay.
Now, my lords, on this aspect itself, my lords,
Yes.
I will just take your lordships, my lords, to 635, 636 of volume 3, my lord. This is Mukut Kemprite EW 128.
Volume 3.
Yes, my lord.
We'll need a brief written submission from each of the council.
We'll give, my lord. It's ready, my lord. I will hand over, my lords.
Yes.
At page 635, my lords. Here again, my lords, the query was asked by the investigating officer.
Yes.
To seeking information on, my lords, the 5 firms. Down below, I gave reply to the above queries by sending a letter to DSP NI New Delhi, informing that against the above mentioned firms, permits were issued on 31/108 under so-and-so in favor of Debashish Bhattacharya. Registration has been department and there is no contact number, and all permits were valid up to 31/308 and not further renewed. Just have the cross, my lords, the foot of the page, my lords, of Debashish Bhattacharya.
Just for your information, second last line of 635 reads, Debashish Bhattacharya, Lower Haflong and sales.
Son of, no, in favor of, this is son of late so-and-so, Lower Haflong and Hills registration.
Lower Haflong, what you are harping upon. That's
I'm grateful, I'm grateful. Man.
Yes.
Those envelopes your lordship saw, my lords, were Haflong. I'm really grateful, my lords. Now, my lords, 636.
Yes.
Cross-examination of Debashish Bhattacharya. It is correct that after proper verification, I have issued permits in the name of Ma Trading, Loknath, Jit, Borel, and Debashish. It is correct that the above said firms had applied through proper channel with requisite documents, and after verification of the documents, the permits were issued. It is true. Then it says, it is foot of the page. It is true that all the firms were genuine. Please mark this, Miller.
Yes, that's not the issue. The witness has given evidence to the effect that there was no, the registration was not continued beyond 31st March. That is what his evidence is.
Yes, my lord. Then
yes.
The registers contain issuance of permits and renewals of permits are not shown to me in the court. For information, answer to so-and-so was on the basis of information which I collected from the concerned staff of our office. Now let's.
There is, Mr. Chaudhary, there is not even a suggestion to the witness that as a matter of fact, the registration was continued beyond 31st March. What inference is to be drawn from that fact?
Yes,
that you don't even put up a case that the registrations were extended or there was a fresh registration beyond that.
That is, Malak, please have Please have the
Yes.
investigating officer's evidence, my lord, at 794 straight away, my lord. Page
Yes.
794, volume 4.
Yes.
Your lordship says that, my lord.
Volume 4. Yes.
I am reading, my lord, third paragraph from the bottom.
Mm.
From the above documents, Exhibit 393, 394, it is quite clear that the firms Mart Trading of Lower Haflong, Borel Enterprise of Lower Haflong, Jeet Enterprise of Lower Haflong, and so of Devasis of Lower Haflong were in fact registered firms. So, my lord,
There
here-
is no quarrel on that proposition now. There is no
Yeah.
quarrel. But the issue is that if the registration came to an end on 31st March, how could business have been provided
No.
to the firms?
Next para, my lord. I have been
Yes.
shown a document filed by the NIA in the present case, which is however not exhibited, my lord. This is one of my submissions on Melafite investigation, my lord, which is a trade license issued by the Guwahati Municipal Corporation in the name of Messrs. Jeet Enterprise, proprietor Debasis Bhattacharya, Sujit Bhattacharya, which shows that originally the trade license was issued for the year 2007-8 and subsequently it was renewed for the year 2008-9 valid till 31st March 09.
Actually, you are confusing the issue. This is the registration with the NC Hills. The registration of 31st March, what they are talking about, Mukut Comprise says that is regarding registration with the NC Hills. That
Yes,
registration you are referring to, which was valid till 2009, was
Yes, ma'am.
for the Guwahati Municipal Corporation.
Yes, my lord.
So
These are
this is very clear.
These are
Yes.
registered firms, my lord, registered in
They
Guwahati.
have, what the prosecution means to say is that there
Yes,
is a
ma'am.
process of registering with the particular autonomous institution. And
Yes, my
with,
lord.
so far as the Haflong is concerned or NCLs is concerned, you were not registered beyond 31st March. There is no dispute on this aspect.
No, my lord, just have 636 again, my lord, that evidence of Kemp, right?
Read.
The last 3 lines from the bottom.
Yes. Registration is all right. Not
Yes.
further extended. There is no question even.
Yes, my lord.
There is not even a question, not even a suggestion that this actually the registration was extended beyond that. There is no suggestion.
Yes, but what
Anyhow,
it says,
yes.
it is true that all the firms were genuine and registered as per rules of North Cachar Hills Autonomous Council.
Ms. Chaudhary, you are confusing in permits and registration. Permits
Yes.
were valid till 31st March. So the business could not have been continued beyond that without extension. Registration is at Guwahati,
Yes, my lord.
not at NCLs. But the NCLs has given you permit to transact with the council.
Yes, my
And
lord.
that is not valid beyond 31st March. All right, we'll see what the effect of that is. You may rethink your arguments on that.
I will rethink it, my lord, and I will place the relevant evidence, my lord. Now, my lord, we go back, my lord, to paragraph 310, my lord.
Yes.
So, my lord, this till 3092, my lord, it is on the existence of the firms.
Yes.
Whether, my lords, the firms were fictitious firms or whether they were existing, they were transacting
Yes.
business.
Mm.
Now, my lords, from 310 is now
Yes.
the incident which they are saying, my lords, which took place in Hotel Pragati Manor.
Mm.
Now, my lords, for this purpose, my lords, they have led the evidence of PW1 Arup Roy.
Mm.
I will just read this paragraph, my lords. The evidence of PW1 Arup Roy reveals that was working as general manager at Hotel Pragati Manor, Guwahati, a 3-star hotel, and is for lodging and food for the year 2008-9. As general manager, his duties were to look after the general administration, other foods and beverages, housekeeping, kitchen and production, maintenance, so and so. For booking a room, a guest has to go to and contact the front office for the booking purpose. When the front office's person will say that the room is available, the guest is willing to take the room, then the front office give one form called GRC. This means the guest details like name, contact number, so and so. He confirmed exhibit 1, 2, 3, the guest registration cards of Pragati Manor. And the guest was one Mr. Jayanta Kumar Ghosh. And the room allotted on 21-309 was room number 302 was allotted exhibit 1. He has check-in on 21-309 at 5 p.m. and 23-309 at 12 noon. By exhibit 2, Jayanto Ghosh was allotted room number 504 on 19-309 and the check-in time was 11:30 a.m. and checkout date was 23-309. By exhibit 3, Jayanto Ghosh was allotted room number 505 on 21-309 and check-in time was 11 a.m. Checkout time is so-and-so. Exhibit 4 is the identity card. Exhibit 5 and 6 are 2 copies of the guest registers where 21-309 and 19-301. JK
Why are
Ghosh
you
was-
reading all these details? What is the relevance?
The
Come to
relevance is,
relevant part of it.
yes, my lord. The relevant part, my lord, is this gentleman who was examined, my lord, as a witness, PW1, was, my lord, an ex-employee of that hotel.
Yes.
He came with a few loose sheets of papers, which were sought to be examined, exhibited. It was objected to by the counsel for the accused, saying, A, you are not the maker of the document. B, the register, you have not carried the register, you have carried loose sheets, the section 34 Evidence Act argument.
Yes.
So those objections were raised. The learned trial court, my lord, did not go into those objections. And just 311, if your lordship see, my lords, the evidence of PW1 finds support. I'm sorry, the evidence of PW1 finds support from the evidence of PW116, Mr. Jiten Bania, whose evidence reveals that in the year 2009, he was front office executive in Hotel Pragati Manor. At that time, general manager of hotel was Arup Roy. His duty as front office executive was to receive the guests, and if the rooms are available, provide them its. So my lord, these 2 witnesses were examined to prove the fact that Jayanta Kumar Ghosh checked into the hotel Pragati Manor on so-and-so date. And he was a guest of that hotel during the time when this alleged incident took place. Now, my lords, both these witnesses, when they were examined, they didn't even identify the accused person. They don't even say that I know him, I've seen him, not of that kind. So the documents which they relied upon, my lords, I will place, my lords, at the end the argument that these documents are inadmissible in evidence. They were not the maker of the document. They admit that handwriting is not ours. We are not the maker. And even the fact that they were carrying loose sheets from the guest register, my lords, that argument under section 34 was taken, which has not been considered. Now, please see
Presuming that, just Ms. Chaudhary, presuming that they say or they prove that you stayed in the hotel.
Yes.
What turns on that?
Nothing turns, my lords.
Do they state about the presence of Mohit Hosai in the hotel?
Yes, they say.
Any other witness say?
Yes, they say that Mohit Hosai came to the hotel that day. Not these 2 witnesses, my lords. It is by PW94, Mr. KV Mukherjee. KV Mukherjee says that I was called by Mohit Hosai to the hotel, where I was given direction to release the funds to Mr. Ghosh.
Okay.
Now, my lords, at 2079 para 312 minutes, they record the submission, my lords. The learned counsel for the accused during argument and also in the synopsis of written arguments, so-and-so, that exhibit so-and-so purported loose guest registration card. Exhibit 5 and 6 are purported loose guest register, and some manipulations are there, rendering they were inadmissible. But just see the approach, my lord. But a conjoint reading of evidence of PW1 and 116 leave no manner of doubt about the genuineness of the same. It is of course true that exhibit 5 and 6 are loose sheets, and as such, the requirement of 34 evidence set cannot be said to be satisfied. But even for the sake of argument, if we discard exhibit 5 and 6, yet rest of the evidence on record are sufficient to establish the presence of accused Jayanta Kumar Ghosh in the Hotel Pragati Manor on the dates mentioned earlier. My respectful submission is, what is this rest of the evidence, my lords, is not discussed. But then subsequent sentence says, PW 94 is another witness who confirmed the presence of accused so-and-so and one Nepali boy in the Hotel Pragati Manor on the relevant date. PW 94's evidence, my lords, is important. My lords, I will take your lordship's liberty to read that evidence, my lords.
Yes.
Now, one aspect I just wanted to point out here, my lords, that there were PW 94, my lords, is the executive engineer, and then at that point of time, my lords, he was working also as the additional chief engineer of Haflong. Now, my lords, there were various witnesses which were coming, my lords, from the PHC department, who would have deposed my lords on the same fact. So what happened, my lords, was that an application was filed before the learned trial court. That's something important, my lords. An application was filed on 3rd November 2009. Sorry, my lords, an application was filed before the trial court stating that these witnesses will depose on the same fact. So under section 231(2) of the CRPC, we let their evidence be deferred so that after that examination in chief, each one of them will be cross-examined.
Right.
So my lord, that prayer was granted by the learned trial court, my lord, without any contest by the NIA. This is important, my lord, because the trial judges sought to draw an adverse inference against, my lord, the accused. On 31st July 2015, my lords, my friends will hand over the copy of the order.
We are having that. We are having that. Yes.
Yes, sir. 31st July 15, if your lordship see, my lords, the third paragraph. I'm grateful, my lords. Seen petition number 987-15 and 993-15 filed by accused Debasis Bhattacharya, praying for recording of evidence of each group of witnesses belonging to PHC division of Maibong, Haflong, and Umrangso. It is submitted that the witnesses of each group, as per the statement of 161, are likely to depose same facts, and hence, if each witness is not set of witnesses not cross-examined on a single day or continuously, it may prejudice the defense. Learned PPP and I fairly submitted he has no difficulty in bringing each of the witnesses on a given day. So, my lords, permission was granted. Now, my lord, based on this permission, my lords, Mr. Mukherjee, KB Mukherjee was called for evidence, my lords. Give me a moment. His evidence was examination in chief was recorded and cross was deferred.
PW 94.
PW 94, 536, volume 3.
Yes, 536. Yes.
The lordship will see at 538, foot of the page, cross-examination of all accused persons is kept reserved. And then, my lords, he was eventually cross-examined on 8th October 2015.
Yes.
So after 2 weeks, my lords, not even 2 weeks, my lords, first 31st September and 8th October, around 8th day he was cross-examined.
Yes.
Well, let's have his cross-examination. First is evidence in chief, my lords. He is one of the alleged witnesses who was there, my lords, in Pragati manner, which the prosecution is trying to prove. I joined PhD department NC Hills in the year 2009 as executive engineer with additional charge of additional chief engineer. During that time, the CEM of the council was Mohit Hojai. On my joining, I received the charges of executive engineer as well as additional chief engineer, PHE, as per the order given by CEM. After that, CEM Mohit Hojai had given me an order to issue supply order in favor of Mart Trading, JIT and Loknath. Accordingly, I had issued supply orders of approximately 1.64 crores. I have received 60% of the materials, approximately. The balance 40% materials not supplied to the supplier, supplied by the supplier. I have given several reminders to deliver the balance material, but the supplier failed to supply the balance material. At that time, CEM Mohit Hojai had given me pressure to release all the funds. But this is what he's saying, without further delay. After getting serious warning from CEM, I had complied to release the complete funds without receiving the balance 40% material. I came to Guwahati, well, he does not give any date, after taking verbal permission from the principal secretary due to my wife's illness. So, he's moving out of the station, he says is a verbal permission. After that, CEM Mohit Hojai called me at Hotel Pragati Manor, and I met Dhruva Ghosh. Dhruva is alias Jayanta Kumar Ghosh, Devasis Bhattacharya. After that, executive engineer of Maibong, Sri Kutum Namasudra, came to the hotel. Namasudra is dropped as a witness. He is not examined. And at that time, CEM Mohit Hojai directed me to issue all the checks in favor of Mart Trading. He also has given assurance that the balance materials will be supplied very soon by Mart Trading. After that, just mark this part. After that, one Nepalese boy who accompanied Mohit Hojai also threatened me to issue the checks as directed by the CM, and accordingly, I had issued the checks in favor of Ma Trading. Well, I pause here for a moment, my lord. This Nepalese boy was introduced first time in his examination in chief. In his 161 statement, there is not even a whisper about a Nepalese boy. Now let's read further. The boy who was accompanying Mr. Mohit Hojai threatened on gunpoint and told me to issue the checks. After being threatened, I got scared of my life and future, and I went back to Haflong and issued all the checks. For making up the short supply of the material, Ma Trading issued checks of various amounts to the supplier, but since in the meantime the account was seized by the NIA, those checks could not be encased and materials were not received by us. Now the lordships will turn the page. Let's come to the cross-examination. So this, your lordship saw, happened on 30th September, and his cross-examination is on 8th October.
Yes.
Your lordships will see, I'll read somewhere from the middle. I went through the files as and when required. Your lordship has that. The tender of supply of GI pipes by Ma Trading, some of which were accepted earlier, and some of which were also accepted by me subsequently. Before my joining, also several tender of Ma Trading for supply of GI pipes were also accepted and supply order issued before my joining. I cannot say the exact amount involved in the issue of supply order in respect of GI pipes by Ma Trading. I also cannot remember the exact amount of supply orders of GI pipes to Ma Trading during my tenure in office. In the month of March 2009, I remember to have issued supply orders of GI pipe to Ma Trading. I was called by Mohit Hojai over telephone in my personal mobile, but at present I no longer subscribe the same number, and I have forgotten my number at the relevant time. I also do not remember from which telephone Mohit Hojai telephoned me. On the relevant day, I came to Chief Engineer office to Guwahati, but I cannot show any document to substantiate that I came to Chief Engineer's office on that day. I also cannot remember the exact date. It is not a fact that Mohit Hojai did not call me over the telephone that day. On the relevant day, some of the bills of Ma Trading were pending, and as CEM of Autonomous Council, Mohit Hojai directed me in the premises of Hotel Pragati Manor to clear these bills. Mohit Hojai did not threaten me. He says this, my lords. But when I came out of the room of Mohit Hojai, one unknown person threatened me, but I do not know him. So the ghost he has created, now he's trying to explain that he was outside the room, unknown person, I do not know him. I did not inform my superior authority of police or police officer anything regarding the threatening received from the unknown person. This unknown person was not a member of the Autonomous Council. The intimidation given to me by the unknown person was in the form of warning. And if I do not have to stay in NC, I have to behave properly. But initially, he said he was given a gunpoint. And before providing data to NIA as per request given to me by DSP, I took approval from the concerned, the notes. So please have the cross-examination for accused Jayanta Ghosh and Devasis. I have been a government servant from 1982. It is not a fact that Mr. Kalol Bhattacharya is a relative of mine from me. It is correct that I had not given any supply order in favor of Jeet Enterprise and Loknath Trading under my signature. The total material supplied by Ma Trading as per the supply orders as calculated by me through my statement in examination chief, that 60% of the materials have been supplied comes to 98.4 lakhs. 98.4 lakhs we have already supplied. It is correct that the material I talked about in my examination in chief is GI pipes. It is correct that I did not state in my statement before NIA that I had come to Guwahati after taking verbal permission from Principal Secretary due to illness of my wife. It is correct that I stated before this Honorable Court in my examination in chief that I came to Guwahati after taking verbal permission from Principal Secretary due to my wife's illness on 30th September 2015. It is correct between the period 26/7 and 30th September, I did not state this fact before about my coming to Guwahati with the verbal permission of the Principal Secretary due to my wife's illness to any authority. It is correct I was an executive engineer PhD from 26/2/09 to 2012. Then, my lords, please come, my lords, to the last paragraph. It is correct that I made a requisition for the funds as executive engineer PhD Haflong for an amount of, please mark, my lord, 1,80,90,000 for the purposes of GI pipe and maintenance to the district council. It is correct that the requisition for an amount of 1,80,00,000 for purchase of GI pipes and maintenance to the district council is prior to 16/3/09. So, my lord, the evidence which is giving that he was threatened in Pragati Manor, my lords, the Pragati Manor incident, though my lord, date is not given, in the charge sheet it says 20th-21st March 2009. 20-21 March 2009. But he had already requisitioned the amount on 16/3/09. It is correct that one of the requisition bearing so-and-so for an amount of 1.77 crores under my signature as executive engineer in the file marked D45, exhibit 221 is available on the record of this case, but was not exhibited by me during my examination in chief held on 30th September. It is not a fact that my statement in examination in chief that after one Nepalese boy so-and-so, he denies the suggestion. Then please turn over the page, minutes. Second line from the top, it is correct. The Lordship has that my statement under 161 CRPC before the NIA, I did not mention about me being threatened on gunpoint. It is correct that I did not give any report regarding me being threatened on gunpoint to any authority or police station till date. There is no complaint or FIR regarding the alleged incident. There is no reporting of the incident to any superior officer. It is true that I have stated about me being threatened on gunpoint for the first time after the alleged incident on court on 30th/9/2015. It is correct, please mark this part. It is correct that my statement in examination in chief that I was threatened on gunpoint is a false statement. Similarly, he eventually breaks down during the cross and he says, yes, that's a false statement. Then there's 5 lines from the bottom. It is correct that the supply order issued by me in favor of March rating is as per the revised rate of supply of GI pipes as approved by the Autonomous Council. I have heard that certain GI pipes which are meant for Haflong sent by March rating was wrongly received at Maibong subdivision. It was sent back to Haflong. So some went wrongly, it was sent back to him. It is correct that I had not taken any station leave permission with effect from 1st March 09 till 31st March 09. It is correct that my statement on the ones I mentioned so-and-so was the 3rd week of March and most probably 28th March. So this part of the evidence where he eventually withdrew that statement and he said that it is an incorrect statement has been taken exception by the learned trial judge.
Yes.
The learned trial court heads, my lords. Now I take your lordships back, my lords, to paragraph 313.
Yes.
But the relevant part, my lords, where an exception is drawn by the trial court is at page 2083, paragraph 321. The lordship has done, my lords?
Yes.
It is, however, true, 320 my lords, 3rd line, 2nd line. It is, however, true that PW 94 during cross-examination first denied the defense suggestion. He was falsely stated, but subsequently he admitted that his statement of threatening by a Nepalese boy is a false statement. Now the question is, what will be the impact of such a suggestion, which at first point is denied and admitted subsequently? The learned special PP has submitted that the examination in chief was recorded on 30th September, but on filing of the petition by the accused, his cross-examination was deferred till 8/10/2015. This is incorrect, my lords. The deferment happened prior to his deposition on 31st July 17. Referring to Akhil Javed versus so-and-so, judgment completely inapplicable. The learned PP has submitted that in between many things can happen and nothing can be ruled out. Then 322, the rival submission is that the accused filed a petition on the 231-2 on CRPC on 30th September for examination of all witnesses relating to PHC Maibong so that they can be cross-examined together, otherwise the defense will be disclosed. And the said petition was allowed by the court, and because of this cross-examination deferred only for 1 week, not for 2 months, as in the case referred to by the learned PP. Then 323. There is no ambiguity on the point that the cross-examination of PW 94 was deferred at the instance of the accused. While the examination in chief was recorded on 30th September, his cross-examination was deferred till 8th October. The ground assigned for such adjournment and the mandatory nature of section 1, I think it was his note overriding on section 231 CRPC is no doubt a matter to be looked into seriously. So what the trial judge feels, I submit was that in view of mandate of 309 and its effect on section 231 may be required to be considered seriously. It is true that in the instant case, the duration of the adjournment is 8 days, whereas in the case of Akhil, the duration of adjournment was 2 months. Now, can it be said that because of shorter duration, the law laid down in this case is not applicable to the present case? Can it be ruled that nothing could have happened within 8 days or even in day also? Our considered opinion is that it may happen even in a moment also. Having found so, we are not impressed with the submission of learned counsel for the accused. We have gone through the case law referred to by the learned counsel. We find that the same proceeds on its own facts, not applicable at all in the fact section. Similarly, discards, my lords, an addition made by the during cross-examination the learned trial judge seeks to raise a suspicion on the conduct of the accused and says that in view of 309, we don't know whether 231 could have been, which will override. Well, learned trial judge does not record that that application was allowed on a concession by the NIA. Well, NIA considered to this.
Okay. Yes.
Then it goes on, then it says, at para 325-2085.
Yes.
A dispassionate analysis, my lord has that. A dispassionate analysis of the above evidence reveals that the same suggestion was asked twice. While in the first time the witness denied the suggestion, in the second time he admitted his statement in examination chief that he was threatened on gunpoint is a false statement. Having stood embedded absolutely firmly in his examination chief, and also he admitted late that his statement of threatening on gunpoint is a false statement. Now the question that creeps in the mind is why the same suggestion was given twice, and was it permissible to repeat the same suggestion twice? Was it to get a favorable answer? There is no plausible answer to this. Now, how do we give an answer to this? Absence of plausible answer has further deepened the doubt so expressed by the learned prosecutor that anything can happen in the number. So the trial court then holds against me that maybe I tried to influence the witness or maybe coerce the witness, which in my respectful submission, is completely contrary to the records. The fact that the application was filed, application was allowed, not one but 4 witnesses were to be cross-examined together because they were coming from the same PHA department. And then the last line, it is further submitted that in the whole trial, the defense side has taken a lot of adjustments for this or that matter, and it took more than 4 years to examine 140. This, is again contrary to the records. 207 compliance, for documents, the NIA took 2.5 years. Eventually, the High Court gave a direction, to the NIA to disclose all the records, the documents relied upon to the accused persons.
No.
So this inference, with respect of the trial judge, is untenable, and contrary to, and to put that against me, in my respectful submission, is without any merit. May I continue tomorrow, It's already, in fact, I have to go and cast my vote also today, in the Supreme Court Bar Association. Till 5 o'clock it's there. I'm grateful, I'll be there tomorrow.